Welcome to the Foul Play YouTube channel.
Hello everyone, greetings and salutations to a special open mic. Really just kind of making some changes here because we literally just got Zellner's reply. So, or not Zellner's, but the state's reply to KZ's brief to the Wisconsin Supreme Court. So we're going to read that first. And I'm going to have Susan read it. Actually, I'm probably just going to do that. Then we'll jump into what we had planned on next. I'll get everybody introduced because right now it's just basically the reading. So let me get that pulled up here. There we go. So this is 12 pages. It looks like we just kind of scanned through it there. A couple of the footnotes are pretty large, but Susan's has elected to read them. So that's fine. So anytime you're ready, Susan, take it away.
Okay. This is the response opposing petition for review from Josh Call and Lisa Comfer, attorneys for plaintiff respondent. Introduction. This court should deny Avery's petition for review, as he has done throughout this proceeding. In his petition, Avery has egregiously misrepresented the record, as the Court of Appeals repeatedly noted. Footnote 1, see State versus Avery. We note that Avery's counsel misrepresented some key facts underlying this claim in the motion to the Circuit Court and briefing to this court. That Avery misrepresented the facts is immaterial to deciding his Brady and ineffectiveness claims. We point them out because of the high-profile nature of this case and the resulting need, where misrepresentations are particularly egregious, to note where Avery's arguments wholly stray from the facts. The lower court's opinions, and even his own argument. Footnote 2. For example, the state never claimed that bullet FK or FL was used to shoot Halbach in the head. The state's forensic anthropologist found 2 gunshot wound holes in Halbach's skull bones. The medical examiner found the same thing and opined that the cause of death was 2 gunshot wounds to the head. When asked on cross-examination how he could tell either shot was actually fired while Halbach was still alive, and he responded that he could not definitively make that determination, though he had been told by someone else that Halbach's blood was found on one of the bullet fragments, which could have occurred by passing through the brain. At no point did any state's witness testify that the 2 bullets recovered from Avery's garage were actually the 2 bullets used in the fatal shots, as Avery claims. It is Avery, not the Court of Appeals, who grossly misinterpreted the state's forensic evidence. Avery has also miscast his claims in his petition and changes his arguments or raises new ones that he forfeited below. For instance, he now attempts to set up the straw man argument that the Court of Appeals misapplied Strickland versus Washington when evaluating claims that he himself presented as newly discovered evidence and not ineffective assistance in the lower courts. The misrepresentations of this sort in Avery's petition regarding both the law and the facts are too numerous to list. The only question properly raised by this case would be whether the Court of Appeals erred when it found that Avery's motions failed to plead sufficient facts that were actually supported by some evidence to both overcome the procedural bar of Wisconsin Statute 97406 and State versus Escalona Naranjo, and to require an evidentiary hearing. Even a casual review of the record shows that the Court of Appeals correctly applied the law and appropriately held that the Circuit Court was not required to hold a hearing on any of Avery's issues, because Avery's motions were all utterly devoid of factual support sufficient to lead to the conclusions Avery claimed. Avery's motions were insufficiently pled, and the circuit court had discretion to deny them without an evidentiary hearing. So at best, Avery asked this court to engage in error correction of non-existent errors. This court is not an error-correcting court. And there is no compelling legal issue here that meets any of this court's criteria for review. There is nothing novel, unsettled, or any need for clarification about what a defendant must plead in his Section 97406 motion to be entitled to a hearing or to overcome the procedural bar on raising claims that could have been raised earlier, the good old procedural bar. Nor can Avery show that the Court of Appeals' rejection of his claims is in tension with any United States Supreme Court or published Wisconsin cases. Wisconsin Statute Rule 809.262. In short, despite what he appears to believe, the fact that Avery's case was the subject of a television show does not absolve him from following the well-established rules of Wisconsin procedure. It does not entitle him to a hearing on insufficiently pled claims based only on raw speculation and misrepresentations of the facts, and it does not entitle him to this court's review of a perfectly sound decision by the Court of Appeals. This case does not meet any of this court's criteria for review, and there are no compelling reasons for this court to hear it. This court should deny Avery's petition. Argument. This case does not meet any of this court's criteria for review. This court's function is to develop and clarify the law. Blum versus First Auto and Casual Insurance Company. Accordingly, this court does not grant review unless the case presents an important legal issue on which the lower courts need guidance. Wisconsin Statute 809.62, this case does not present such an issue. The Section 97406 motion that Avery filed in June of 2017 was his third motion seeking post-conviction relief. He had a direct appeal in 2011, and he filed a previous Section 97406 motion in 2013. The Circuit Court denied Avery's 2017 motion and his many supplements to it without a hearing because he failed to show a sufficient reason for raising the claims previously, and the record conclusively demonstrated that Avery could not show he would be entitled to relief on any of his claims. Avery misrepresented the conclusions his experts reached and otherwise relied only on wild speculation and conclusory allegations. The Court of Appeals agreed, holding that Avery had not provided a sufficient reason why most of his claims could not be raised previously, and for those which he did provide a sufficient reason, he had not provided sufficient material facts in his motion that were supported by the record that could establish ineffective assistance of counsel, newly discovered evidence, a Brady versus Maryland violation, or a constitutional due process claim. Accordingly, there is no law development to be done here. This court has made it abundantly clear what a defendant must show in a Section 97406 motion to overcome the procedural bar and to entitle the defendant to a hearing. The defendant's motion must provide sufficient material and non-conclusory facts. For example, who, what, where, when, why, and how, that, if true, would entitle him to the relief he seeks. State versus Allen. State versus Sula. The defendant cannot just make broad allegations and hope to flesh them out at an evidentiary hearing, as Avery did here. State versus Bentley. Rather, the motion must provide facts to demonstrate how the defendant would prove each element of such claims at the hearing, where the court is not required to hold one. State versus Romero-Giordano. This court has also held quite clearly that the circuit court does not need to hold a hearing if the defendant's motion makes conclusory allegations, or if the record conclusively demonstrates that the defendant is due no relief. Allen. In other words, contrary to what Avery claims, it is well established that the circuit court does not have to grant a hearing on allegations pled in the motion that the record demonstrates are not true. And as the Court of Appeals properly recognized, the claims Avery made in his motions were misleading, contradicted by the record, speculative, and did not contain sufficient material facts that would establish what he claimed. Avery's new experts all reached conclusions that were consistent with Avery's guilt, and in his motion, Avery simply falsely represented what they said, meaning it would be impossible for him to establish at a hearing that trial or post-conviction counsel were ineffective for failing to conduct these tests, nor could he meet his burden to prevail on a newly discovered evidence claim. Virtually all of the contents of the Beeley CD were indisputably turned over to the defense, along with Agent Fassbender's investigative summary telling Avery what the state found on the Dassey computer, meaning Avery did not plead sufficient facts showing how he could prove a Brady violation even if a hearing took place. And there is no due process right to post-conviction DNA testing, so Avery did not even plead a cognizable claim about the bone fragments. But even so, Avery did not provide any facts that, if true, would show that if the bones from the Manitowoc gravel pit were human and the victims, he could not be the killer and the person who put them there. He did not plead sufficient facts to explain why the bone fragments could be actually or even potentially exculpatory. Accordingly, he failed to plead facts to show how or why this evidence was at all material. The Court of Appeals did not require Avery to prove his claims in his motion. It required him to state facts that would lead to the conclusions he reached in his motion if he proved those facts at a hearing. That is precisely the proper pleading standard for a Section 97406 motion. Allen. It has also long been settled that this standard also includes providing material facts to establish a sufficient reason why the claims now raised were not raised in a previous motion or on direct appeal. Escalona Naranjo. And mere pro se status or indigency, which was the only reason Avery provided for not raising his claims in 2013, is not a sufficient reason. Finally, it is beyond argument that statutory claims, such as Avery's argument that the state violated Section 968.205, which it did not do in any event, cannot be raised in a Section 97406 motion, State versus Carter. The Supreme Court has also made it crystal clear that Arizona versus Youngblood does not apply to destruction of evidence post-conviction, nor recognize a due process right to post-conviction DNA testing, meaning Avery did not raise any cognizable constitutional claim regarding the state's releasing some of the bone fragments to the Halbach family after Avery's appeal concluded in 2011. See District Attorney's Office for the 3rd Judicial District versus Osborne. In short, Avery's motion did not include sufficient material facts that would entitle him to a hearing because he did not provide sufficient facts that would entitle him to the relief he seeks. In other words, his motion was insufficient because he did not allege sufficient facts that were supported by the record to show that he could establish any constitutional violations at a hearing. So, the record shows that the Court of Appeals did not hold Avery to a higher pleading standard as he claims. It required of him the exact same thing that is required of every criminal defendant who files a Section 97406 motion. Sufficient non-conclusory facts, actual facts, not guesswork, speculation, or fiction, to show that a hearing would not be frivolous. Romero Georgiana. Avery simply did not meet his pleading burden, nor did the Court of Appeals improperly fail to consider the cumulative effect of Avery's claims. The Court of Appeals found each of these arguments to be without substance. Adding them together adds nothing. 0 plus 0 equals 0.
Oh my God.
Mentech versus State. These pleading standards and what constitutes sufficient material and non-conclusory facts to entitle the defendant to a hearing have been fully articulated for decades, and in cases too numerous to count. They're too numerous to say as well. There is no need for this court to rehash them. This case does not present any novel, unsettled, or important legal issues, and the Court of Appeals opinion applying the pleading standard is exactly in line with the decision. In line with the decisions of this court and the Supreme Court. This case does not present any novel, unsettled, or important legal issues, and the Court of Appeals opinion applying the pleading standard is exactly in line with the decisions of this court and the Supreme Court of the United States. Review here would be simply another walk down the extremely well-trodden path of the pleading standard for Section 97406 motions. There is no need for further clarification of the pleading standard. Courts across the state easily and properly apply it every day. This court's scarce resources should not be spent reviewing the Court of Appeals' simple and correct application of a standard that has already been exhaustively explained in existing case law. Conclusion: this court should deny Avery's petition for review. Oh, brother.
Thank you very much. Excellent reading. Terrible material. Wow.
Jesus.
Wow. Well, all I got to say about that, in my opinion, and I'm not a lawyer, I play one on TV. Bullcrap.
Yeah, that is a load of bollocks. What they're saying, that is basically, I said, you said. You know what I mean? It's ridiculous what they've just put in that report. The fact is they gave away bonds which broke their own law, and for that not to concern anybody is disgusting.
Well, that's the thing, they're saying that no law was broken, but I guess at the, from us non-lawyers looking at the outside of the glass looking in, I mean, Dr. Silkman's here. He's a smart man. I mean, from my standpoint, hey, Doc, from my standpoint.
We do have a lawyer here. Not to put anybody on the spot, but Sammy Burtis is a lawyer, right?
I think so. But,
I don't know, from Mike's
I'm saying this from from the outside looking in, they went, literally, I guess at the end of the 2011 hearings, direct appeal, when Hagopian had Avery's case, and they went and took Eisenberg's notes. They went down to the evidence locker and they pulled out X, Y, Z, everything labeled as under those tags as human, bundled them up, put the rest back, and they took them to the Whiting Funeral Home. I don't know how much clearer. I mean, to me, I don't see how that's not a problem. But again, I'm not a lawyer. Well, let's, before we get rolling here too far, let's introduce everybody. Everybody say hi. Alice.
Hello, everyone. Thanks for joining.
BB.
Hey, everyone.
Susan, we know. Say hi, Susan.
Hi, sorry about the phone call.
That's okay. Thanks for doing the reading. Appreciate that.
You bet.
Welcome back, Rhonda. Woohoo!
Thank you. Good to be back.
So good to have you.
Thank you.
Jinxie, great live today.
Peeks in and thank you.
Neverly, Lady Neverly.
Everybody.
Are you at work?
Yep.
Good for you. Keep
She
both
works
arms.
hard for her money.
Try to keep both arms the same length. That's all I got to say. Nosy.
Hi, everyone.
Dr. Silkman, how are you doing, sir?
Well, I was doing really good until I heard that reading and I threw up my breakfast.
It's early for you.
Apart from that, that's all I've got.
It was pretty terrible. I have to agree with you. Well, I mean, we literally, like I said, when we went live, we literally just got this like 5 minutes because, I mean, the original intent, we're still going to do it, of this of today's special open mic is so I got some material. There were several hearings in 2009 for Brendan, so that's what today's original intent was. We figured that we would get this document that Susan just read tomorrow. We figured that we'd get it last second, like normal. But we would, got it, so we wanted to go ahead and get that out there and get it read. And I think there's all kinds of problems with it without really having a chance to diverge too much into it. But, one part he read there I found really interesting, or she read that he's talking about the Bailey CD and that they had all this material, including Fassbender's own report. I can tell you from memory right now, that's DCI report 304. And while he did include some things in it, there is in no way a full accounting of what's on that CD. No way. And it's been probably a month since I've read that report, maybe longer than that. So that's wrong. And plus, they didn't even bring up, he didn't even bring up all the numerous factual errors that the Court of Appeals made in applying their decision. There are a lot of errors in their decision. I don't know. I just see a complete, there's nothing new to see here. Let's play dodgeball. Don't want to touch it. So, anybody else wants to comment before we move on to the original intent of our podcast tonight, please do so.
Can I just make a quick comment?
Please.
Yeah, none of us should really be surprised by that response. It's really much of the same. And a lot of people have commented in chat that they probably took 5 minutes to put that response together because all they did was cut and paste from other responses and other documents. It's very infuriating because we know what the state is trying to do. And they actually said the key word in that document. They don't want Kathleen Zellner to flesh it out in court, right? Because therefore, if she can flesh out her arguments in court, it's going to look really bad. So what they're trying to do, their absolute utmost best, is they're trying to put a roadblock right from start. So the way that was written was, hey, guys, forget about the bullet, forget about, the bones. There's nothing to see here. And this is a reminder to everyone how blatant the corruption is, right? We've all studied the bullet. We've all studied the cremains. We've all studied the Veely CD. We know that the state did so much wrong. Yet, here's a document stating in black and white, hey, we did nothing wrong. Avery's got nothing to claim. See you later. Go away.
Yep. Nothing to see here, right? That's what I got from that document.
Correct.
Yeah, that's exactly.
It's also interesting how they completely overlooked Kathleen's claim that, because Stephen was not found guilty of mutilation of a corpse and about moving the bone fragments and such.
Didn't even mention it.
Yeah. They said the same thing they said before about the bone fragments being exculpatory.
It just blows my mind. And, again, interpretation of how that law is written and how it's applied in court. I mean, it seems to be, it's like, to me, it's like they're just basically saying that don't pay attention to, I think it's 968-205, I think it's the number. That only applies in certain situations, but this is not one of them. I really don't understand. And, and here's another thing. If the bones really didn't matter if they gave him back or not, why didn't they give him back in 2005 or 2006? That's my question. Because clearly they were going to do it anyway. So why wait 4 years, 5 years, whatever? So anyway, any questions from the?
So they gave the bones back in 2011. Now let's not remember that Stephen Avery was the first person to be exonerated under that new law for DNA testing back in 2003. He was the first exoneree under that DNA thing, right? So in the Wisconsin Innocence Project is who picked that up, had the DNA tested in the first case. Now in 2011, because they have this law in place in 2009 and 2011, they had that law in place. They were getting benefits from the federal government, like what do they call those?
That grant?
Grants.
That grant money?
For the Wisconsin's Innocent Project to then turn around and test people's DNA evidence who are saying they are innocent. And not even 2 or 3 days later or the next day, they got rid of the bones. That's very suspicious too. Like the law don't matter. Obviously, the law mattered that they had to get rid of the bones so quick so the Innocence Project didn't come and free Avery again. That's how I see it.
Well, I mean, what did you dig up and find that they got like $1 million? Is that right?
It was in August they had gotten like 670 or some. They got like 375 million, and then in right in September they got it another portion like 700,000, which made it to be 1 million total that summer.
Wow. Of
grants from the federal government to do testing for these wrongfully convicted men and women in prison. So
plenty of money to do that rapid field DNA test, whatever it's called.
Yeah, it's called the Andy rapid DNA technique. And look, there's no question. There's no question about it. And as people in the chat have already alluded to, timing is important here. Yep. You think about all the controversy that the Innocence Project did in exonerating Stephen Avery and the first time round. And could you imagine, as Mystic Jinx pointed out, what the consequences to the state would have been if Stephen Avery was exonerated again by the Innocence Project? So this new technique came out several years ago, the anti-rapid DNA technique. Now, I'm telling you right now, the people in the Wisconsin State Crime Lab, the lawyers, the Attorney General's office, they would have known and read about these new emerging techniques because they were used in the California fire. There was a big fire in California, and the inventor of the technique was successful in obtaining DNA from heavily burnt cremains, right? So hence, timing-wise, I'm sure the state thought, hey, we better get rid of these cremains before they're tested, right? So now, if you have a look at what was written down in that review, now they're saying that the bones, remember the argument was the bones that were given back were not proven to be human, right? Because the people that actually took out the cremains, they weren't forensic anthropologists, right? So that's the excuse that they used. Now they're turning it around and saying, okay, if those cremains at the Manitowoc County gravel pit are indeed from Teresa Halbach, Stephen Avery proved that it wasn't him, right? So they're putting the bar so high that the person who committed this horrible act and left the cremains there, they have to sign a confession to say they did it and not Stephen. So what they're saying is this: they're taking away the rug from underneath Kathleen Zellner by saying, hey, even if you had the cremains, even if you prove they were Teresa's, you can't prove that Stephen Avery didn't dispose of them there, right? So the bar is set so high, they're trying to entrap Stephen and, of course, tell Kathleen Zellner where to go. And it's really shocking.
So he'd be like Mark Dassey talked about the unindicted co-defendant.
Oh, that's correct. So even though DNA evidence proves that it wasn't Stephen, the prosecuting attorneys will still go for the unindicted co-conspirator. Oh yeah, okay, Stephen didn't do that, but somebody else did. They worked together.
Yeah.
Because when you think about it, the bottom line is this: they got to protect the verdicts at all costs.
Absolutely.
And the way that briefing was written was, hey, look, guys, don't bother. Don't bother.
Yeah. I agree. Okay. Before we move on, is there any questions or comments from the chat that we need to, anyone see anything that we need to cover? Because this next part's it's going to take some time. But,
Can I?
Grandma did ask what happens now, and I think that is we wait, more waiting.
Yeah. What's that, Doc?
I was going to say, I know I'm going to get burnt at the stake for doing this, but I'm telling you right now, Kathleen Zellner needs to get someone from the inside of the Wisconsin legal system, invite them over, hire them, and sit with them and tell them and ask them, okay, exactly what do I need to do to write a successful brief? I know that sounds funny, because if you look at the response, they are mocking Kathleen Zellner in the way she approached her filing.
Yeah.
Right? So they're basically saying, oh, no, Stephen Avery should have done this. Well, Kathleen Zellner, I think, needs to go down there, hire one of them, and say, right, what do I need to do to write a successful application? I know it sounds funny. I know it sounds concrete. But guys, Kathleen Zellner has put in so many filings, and all they're doing is putting up a brick wall, right? She needs to break through that brick wall.
I agree. I don't think it's wrong at all, what you're saying, Doc.
And what you mean by hiring somebody from Wisconsin is to point out the actual Wisconsin law, right? Because she's obviously very capable.
Correct.
You're not saying that she's not capable.
No.
You're saying
No.
somebody who's going to advise her specifically on Wisconsin law.
There's no doubt that this is a Wisconsin law issue. A Wisconsin law issue. If this occurred in any other state, I'm sure Stephen would have got the evidentiary hearing. But for some unknown reason, and guys, we know why, in Wisconsin, they're being they're putting blocks at every opportunity. That's got to stop. That honestly has to stop. Otherwise, Kathleen Zellner will go round in circles, and Stephen and Brendan will die in prison.
Yeah.
Right?
Yeah.
All because... Sorry.
Go ahead.
I was going to say, all because of legalities and the way a document is written and expressed. It's complete garbage.
Nan's Life says Richards is a Wisconsin attorney on her team.
Well, if that's the case, then how come they're shooting holes in her filing? How come
Because
they're almost...
procedurally barred.
That's correct. So if something, no, guys, you got to understand, if something is procedurally barred, they will not look at it. It's like a kid who hasn't handed in his homework and the teacher says, you're getting 0. And the kid does his homework, is late, and has perfect answers. And the kid goes to the teacher, look, all my answers are correct. The teacher will still give him 0 and not even look at it. That's what they're doing to Kathleen Zellner. They're saying, no. We don't want to know any of this. We've explained it. Go away. As disgusting as that is.
Yeah.
It's inexplicable.
It is.
T1's got a question. Was this response given just before the deadline intentional? Thoughts?
Well, they had to give it tomorrow anyway, so I'm not going to read too much into it being, a day early. Maybe, I guess, but anyone else got a thought about that?
Well, I mean, there has to be, in my opinion, a novel angle that's going to knock over the Wisconsin state system off their feet. Kathleen Zellner has to find that novel angle in which they have to respond in a positive manner, right? I've never seen anyone hire all these experts, take the forensic material apart, and yet is still no better than Stephen having nobody. How can you work that one out? Right? Everything has been disputed, and yet they're behaving as though it's all trivial.
Right. I think maybe that part of that's an act because they know that it's, her experts are real. They're world renowned. They know their stuff. And they made claims that his own experts proved him guilty. What? I didn't get that at all from them. I mean, I know that they're not going to, tell a falsehood, or they're not just going to say because she hired them, hey, this guy didn't do it. They're not going to do that. It's their reputation. So I don't know, Doc. It's kind of like we were just talking about a minute ago. And they're saying now, before there was like, oh, well, we don't know if they were human or not. Now they're saying, well, even if they were human, that doesn't mean he wasn't a unindicted co-defendant or, co-conspirator or whatever. They're shifting the goalpost. That's what I got from that. And it's kind of like seemingly that way throughout all of it. They always want to shift. So I'm not entirely sure that she will ever get real satisfaction unless, one of these judges says, hey, look, what's going on here? Because we've got two really opposing arguments here, and there's merit maybe with both. Let's get it into a hearing and find out.
I mean, she could see federal relief. Who knows how long that would take?
I'm afraid I would really like to see it state level because federal, you get hand tying because of ADEPA, or however you want to say it.
Well, she said that she doesn't want to go federal, didn't she?
Unless she has to. Again, because of the crime bill and the anti-terrorism law that it constricts the federal what they can do to untie states' court's decisions. So
the only hope I see is possibly if they get an honest conviction integrity unit in this state or something like that to, have a true look at it.
Doc?
I was going to say, I mean, if you look at the responses that we've read out so far, they're uniform. They don't stray. All they conclude is that Stephen Avery hasn't got a leg to stand on, right? And that they don't even give an opening or something that Kathleen Zellner can pursue. And we got to understand what is the bottom line here. The bottom line is this. This is a highly publicized case, right? It's been seen by millions of people and it's spoken about every day by a lot of people. So there's a lot of publicity behind it. Yep. You've got all the things that happened to Stephen in 1985, right? Which was really, really terrible. And the people that did that to Stephen and his family never went to justice, right? So there's no way that Wisconsin is going to open that door again, right? It simply will not open that door again. Because if Kathleen Zellner has a chance to get in front of a judge, they know they're in big, big trouble, right? Because as the report said, Kathleen Zellner now has the opportunity to flesh it out. They don't want to do that.
No, they don't.
There's another, and then I'll shut up. There's another underlying factor here, and that is the Innocence Project, right? And Mystic Jinx said it, right? The Innocence Project mainly does DNA testing to determine whether that individual was there or not there at a particular crime scene. If you notice in this case, the Innocence Project did not take up Stephen's case again. And when you think about it, I know it sounds harsh, but it probably did the right move, because one thing the prosecutors don't like is to admit that they've made a mistake. Do we all agree with that?
Oh, yeah, absolutely.
Yeah. So imagine if the Innocence Project found Stephen Avery not guilty, and it pointed to somebody else, right? It means that the Innocence Project, in a way, is the enemy of the Wisconsin law, in the state, because the attorneys are putting people in prison. The Innocence Project is trying to take them out.
That's right.
So you've got this incredible conflict going on. And if you look at Ken Kratz's book, he has a go predominantly at both Making a Murderer and the Innocence Project.
That's right. That's right.
They are fearful. They are fearful of the Innocence Project because, think about it, with that civil suit and the depositions that were coming up, that was going to destroy the reputation of the MTSO and also of Dennis Vogel. Imagine if Kathleen Zellner did it again to them, right? A person wrongfully convicted twice, unheard of. Unheard of.
Yeah, they don't want her anywhere near a courtroom hearing.
That's correct. Correct. Thank you.
Yeah, thanks, Doc. It'll be interesting to see, what the Wisconsin Supreme Court does. I hope they take the case, and I hope they push for whatever's necessary to take it to the next step, which I think personally is a evidentiary hearing, and let's just get it settled, because if there's no issue, that'll come out. But I don't think that's the way it'll fly, personally.
No, we've got a couple of questions. T1, why did they feel the need to respond at all? Are they worried the decision will not go their way at the moment? Kind of like, why in the fuck did KK have that PC to sway someone? And then Smart Duck is, if there was an evidentiary hearing, is what KZ has enough to get Stephen Avery acquitted, or does she need to find something when testing the evidence?
And I just want to ask something too, if you don't mind, which is, didn't the Innocent Project eventually pick him back up after Ma'am came out?
They did, but it
wasn't Trish, but Trish. What was her name? Trisha.
Yeah,
her name Bunnell too. Because I just want to say that for some reason.
I want to say, yeah, I think it was, and yeah, they picked him up for a while, and then I don't remember.
And she came on that case.
Yep, that's right. So, as for getting into a hearing, I mean, I think we can all probably just look at what we know, what we've seen, and have uncovered since we really started diving into this case, of the many things that are really questionable. There are always questions in a case like these big murder cases. There are always unanswered questions, and we have to accept that. When I first started looking at really deep into this particular case, not knowing and being really green about not understanding, there are always questions. And I get that now. But there are major, major questions in this case about how it was, the integrity of the investigation, and the things that even today that, we don't have. I mean, I've talked extensively about, and not only me, but, in trying to get open records requests fulfilled, of the simplest things, phone calls. You can't get them. Why not? What's the problem? Is there anything in that phone call that may have led? I'm talking just a certain aspect of the case. I'm not talking about the entire case. I'm not saying that that's going to solve the case. And don't take it that way. I mean, but it could lead a certain aspect of the case. She does have enough to make some substantial gains in an evidentiary hearing that would disprove the state's narrative in 2007. That's my opinion. So I don't know if anybody else wants to speak to that or not, but.
Well, I was going to quickly just say, what the state has got is a deck of cards, right? They're putting bullshit on top of bullshit, and all you got to do is take out one card, and the whole thing will collapse. They know that. Yep. They know that. So they've got to be as strong. They've got to be as strong as possible, as negative as possible, so that the higher courts go, "Oh yeah, okay, we agree. We're not going to waste our time." Right. So it is an illusion, right? And it's a matter of breaking through. If she can break through, I think good things will happen.
Yeah, I agree.
I love Casey's tweet here that says state's response claims there is no Brady violation if the state decides the evidence suppressed from the defense is virtually the same as what it turned over. Said no court ever. Virtually. Yeah. They put these words in there that
add to
just inexplicable.
Yeah, inexplicable. That's your favorite word, isn't it?
Yes, it is.
Yeah, I don't blame you. Okay, well let's move on to this next part, and I'm going to give a little introduction to the Brendan Dassey hearings that I'm going to talk about. And I started going through, because we were almost finished with recording Dassey's jury trial from 2007. I think we're 10 or 15 pages, and that'll be done. And I talked about before about what happened between August of 2007 until January of 2010. So let me pull it up here, and I'll show you guys kind of what I went through and looked at. And what you're going to be looking at is the compilation of a record for Brendan, and it's pretty long. But the thing is that a lot of it's just continuing. Getting an extension, and you see that this numerous times. It's probably listed more than anything about getting these extensions. But you get into. There's also a couple of sections where they've added lawyers and that kind of thing, but. You get into 2009, you can see it here, there were a couple of hearings. So, and you'll see there, May 29th, 2009 motion. This is an ex parte motion filed under seal. And then there was another one on June 23rd, ex parte motion filed under seal. And I don't know for a fact, but I suspect that both of those were the same as there's another hearing that this is what we're going to read out live from June 30th, 2009. This one was also filed under seal. However, and here's another one. Here's an order. I've got this one too, but because the seal has been lifted, I'm going to show that to you. So as you move forward, there's more things listed. This compilation record, anyone can pull it up. This is on the Wisconsin Circuit Court docket, so this is nothing secret. Anyway, you move on up to January 12. This motion hearing, and it's quite lengthy here, as you can see, but there's a section here that Judge Fox talks about this hearing, and it's right here. Okay. It says the court comments, and it's comfortable with the ex parte motion being without the presence of the state. The court orders that the transcripts of the 6/30/2009 ex parte motion hearing be unsealed, but portions on page 79, line 16 to page 80, line 2 to remain redacted. So I've been talking about and wanting to get some of these hearings that are between, just to have a fuller record of Brendan's case. So I emailed the clerk last week and got a response. I actually listed about 10 documents, including the 2 previous ones we looked at about being sealed. However, I'd already looked forward in the record. If you go on up, it just keeps getting closer. And let me go back here and I'll show you about when they make a transcript of a record. See right here on 8/3/2009, 8/3/2009, a transcript was ordered and made for that motion on 6/30. And you'll see that throughout these court cases when a transcript is ordered. It'll list it specifically in the docket. So these other 2 hearings, motions prior to the 6/30 one, I can't find it anywhere, but I wasn't for sure. So I ordered it as well. Well, come to find out they have not been transcribed. And to get a transcript, and I don't know if they're still under seal. I think the seal's been lifted, but they've not been transcribed. And it's $275 per page for to get something transcribed. So that's kind of just out of the way. No way. Be too expensive. So anyway, what I did get was the 6/30 hearing. And we're going to read it, and that's myself, Susan, and Alice, and Rhonda. So I've not read through all of it. I've read through some of it. It's 81 pages. It's supposed to be 83 pages, but as it said as I told you, 2 pages, they wouldn't redact. So they just removed 2 pages because I did try to get those portions and I was denied. So 2 pages 79 and pages 80 are not in this document. So nothing I can do. I did try though. So I hope everybody, again, I've read about 20 pages and this is Michael O'Kelly. Yeah. And I read it, the first 20 pages. It's pretty bad actually. So hope everybody will bear with us. We'll get through this as quickly as we can with us, reading these parts out. This is kind of what we go through in the recording process, but we're doing it live. But I thought this would be interesting since it was an ex parte. This is a defense hearing. So you'll see that what they kind of went through, a little bit of this was in MAM. If you guys will remember, they talked about a little bit about, I think, trying to run down Michael O'Kelly. That's a little bit more explained, at least in a little bit of what I read here. The other interesting part you're going to see right away is that O'Kelly knew that this hearing was coming, and he didn't already have a lawyer hired. You'll see this right here in the beginning. It's quite something. But I think that's, in line with his character, who he is. So I'm going to be playing Dvorak. Rhonda is going to be reading the part of Judge Fox. Alice is going to be reading this lawyer that does come along for, I can't remember his name, Brandt, I think. Grant something. Alice is going to read his part. And Susan is drinking Pepto-Bismol, taking Tom's. She's going to be reading O'Kelly's part. So, without further ado, we're going to read this through, and we may stop and take a short break, give everybody a chance to get a drink here along the way. But other than that, it's about 80 pages. It will take us roughly an hour and 15 minutes to an hour and a half. So with that said, I'm going to start us off, and then Alice, it'll be yours to take. You're the judge. I'm sorry, Rhonda. My bad. Rhonda, it'll be you're the judge. So
You want me to start on page 3, I'm guessing?
yeah, I'm going to read this first part so we got everything in there. All right. Everybody ready? Susan, Alice?
Yep.
Ready.
Okay, here we go. State of Wisconsin Circuit Court, Manitowoc County, Branch 3. Ex-Parte Motion. Case number 06CF88. State of Wisconsin versus Brendan Dassey, filed on, this is when this was filed. Of course, the hearing was on June 30th, 2009. And as you can see, the only witness is Michael O'Kelly.
This is in the matter of the state of Wisconsin versus Brendan R. Dassey. It's case 06CF88. Appearances starting at council table to my left.
Good morning, Your Honor. May it please the court, Attorney Robert Dvorak and Attorney Joss Teffer, appearing for Brendan Dassey.
And you are, sir?
Michael O'Kelly, Your Honor.
All right. I'm going to just spread some information on the record. This is a closed ex parte hearing. This originally began with a letter, I think, dated February 13 from Attorney Dvorak requesting this. Attorney Dvorak recited in the body of his letter the fact that he wanted to get some information from Mr. O'Kelly, who I understand was employed during the prosecution of Brendan Dassey as an investigator for Attorney Leonard Kaczynski, who represented Mr. Dassey for a period of time. Mr. Dvorak, in seeking this ex parte proceeding, cited a case called State Ex-Rel Dressler v. Circuit Court of Racine County, Branch 1, 163, Wisconsin.2D 62242, blah, 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 Court of Appeals, 1991. It's a case from an appeals case from this district. In it, the court, I think Judge Anderson wrote the decision, made at least a reference to another case that I'll cite in a moment, and suggested that under appropriate circumstances, ex parte proceedings could be had in criminal matters. The case that was cited was, United States of America v. Joselito Abro, and that's at 202 F. at 2D 386. I believe it's a 2000 case. The point of the case cited in the Federal Reporter was, and it used, I believe, if I recall, and I didn't reread the case. I think I went through this as a prior motion hearing, was that the public defender, the federal public defender regulations included the right to name experts and not necessarily disclose the naming of those experts, doing it in an ex parte fashion. Court read it. I also consulted with James Alexander, who's the executive director of Wisconsin Judicial Commission, which is a body that has some jurisdiction for ethical and other matters found in Supreme Court Rule Chapter 60, the regulation of judges, and discussed in broad outline was proposed. And discussed in broad outline what was proposed. And he said he didn't know that there was any precedent for it, nor did he know that there was any reason that the court couldn't proceed. With that in mind, I believe I held a motion hearing, and I don't have the date in front of me, an ex parte motion, in which I granted to Mr. Dvorak his request. Since that time, there have been a number of subpoenas that I recall having signed, most recently last week. Additionally, I believe last week we had a request for an order for reasonable expenses that was signed. It's my understanding Mr. O'Kelly is appearing here today pursuant to that subpoena, which was served on him at an out-of-state venue. The matter was set for today for this particular hearing. I'll tell you, Mr. Dvorak, that Mr. Kelly earlier this morning brought some papers which are in the possession of my judicial assistant, who's acting here as the clerk. This morning when I came to my office, I found 2 faxes, one from District Attorney Kenneth Kratz, the Calumet County District Attorney, who was the appointed special prosecutor in the Dassey case. I believe you, Mr. Dvorak, have a copy of that fax. Do
I do, Judge.
you not? And Mr. Mr. Kratz in the fax was questioning what I'll characterize as the legitimacy of the hearing. He cited a case called State v. Kleitzen that he says discusses post-conviction discovery. Had a crowded calendar this morning. I haven't read the case. I'm not looking on this necessarily as post-conviction discovery. It seems to me it's quite something else. Discovery would be an attempt to get some information from the other side in the post-conviction setting. This is simply, as I understand it, an effort to get some information that Mr. Kelly may or may not have generated as part of his employ with Attorney Kuczynski in the defense of Mr. Dassey. I have no idea what is being sought. What I guess is something that I had to consider was if this was information that was inculpatory rather than exculpatory, and if the appeal were granted and a new trial were to be had, it strikes me that it would be unfair to Mr. Dassey's defense to allow this inculpatory information to become part of the public record and then useful or then used on the part of the state. I also had a second fax, and I'm not sure, Mr. Dvorak, if you have gotten this. It is from Attorney Kenneth Rosenfeld. It copies Mr. O'Kelly, but there's no suggestion that you've been copied. Have you seen it?
What's the date of that letter, Judge?
Yesterday, June 29.
And is who's it addressed to?
Me.
No, I have not seen it.
All right. Mr. O'Kelly, have you seen it?
Yes, I have, Your Honor, and I have a complete package of what I gave you, which includes that letter, I believe.
May well be. I haven't looked at it.
I can give this to the attorney.
Why don't you give it to Attorney Dvorak and he can...
The entire packet, or...
You're going to have to... We both can't talk at the same time.
I'm sorry.
Why don't you give him the entire packet? He can, since that's what's going to be turned over to him anyway.
Yes, Your Honor.
And he can isolate the letter. I'll simply ask you to read it right now, Mr. Dvorak.
And Your Honor, while he's reading that letter, I'd like to have an attorney. I did call a Travis Glant. He's a local attorney, and I spoke with his secretary, Debbie, and they could not be here this morning. I do want to have an attorney for this proceeding.
All right, we'll take that up in a minute.
Thank you, Your Honor.
Okay, I reviewed it, Judge.
All right. The gist of the letter is that, and it'll become part of the, at least for this time, the sealed record, that Mr. O'Kelly apparently turned over a box of documents relating to the matters being sought here today to this law office, the Rosenfeld law firm, which apparently moved to a new location. And in the course of the move, the writer of the letter, Mr. Kenneth Rosenfeld, Esquire, says it appears the documents may have been lost during the course of the move. He says that his office is attempting to locate those documents and that Mr. O'Kelly is attempting to reconstruct the record from whatever electronic resources he may have. The letter also points out statute or rule 905.065 that talks about honesty testing devices and privileges that relate to honesty testing devices. Now, before we take up Mr. O'Kelly's request to have a representation here, Mr. Dvorak, is there anything additional that you wish to spread upon the record?
I would just, in terms of clarifying the letter, Mr. Rosenfeld emailed me on June 24th at 12:49 p.m. And I guess the easiest thing to do is just submit a copy of that. I don't have, I believe, I have an extra copy of it. He essentially says that speaks well of Mr. O'Kelly, says that he would not avoid anyone, nor would he ever attempt to circumvent any legal process. Without a question, he is one of the best and most honorable investigators in the United States. Again, there must be a misunderstanding. I'd very much like an opportunity to discuss this with you personally. I do believe this matter can be resolved quickly without the need for extended court process, which leads me to believe that he has this stuff and he just wants to turn it over and maybe we can resolve it that way. I was unable to get back to him. The next day, on June 25, I received a fax from him. The time of the fax is 2:15 with a letter in it that says, "This letter is on behalf of Mr. O'Kelly, who has served as an investigator and expert consultant for our firm in several criminal cases. Mr. O'Kelly has informed us that you have subpoenaed him together with his file in the above entitled matter, and that he is to appear."
Please slow down.
Oh, sorry.
I'm sorry. Before the Circuit Court for Manitowoc County, Wisconsin, on June 30th, 2009. Several months ago, Mr. O'Kelly forwarded his file in this letter to our office via Federal Express. He did not retain a copy of the documents he sent to us. Either shortly before or soon after receiving the box of documents, our office moved to a new location, and it appears, in italicized letters, those documents may have been lost during the move or in the organization of our new offices. I and my staff have searched through every office and storage area in our new building, but as of yet have not located the box. We will, of course, notify you should we locate this box of documents. You may feel free to contact me regarding this matter. That was June 25th. So that's what I got in terms of correspondence with Mr. Rosenfeld. I responded to the 26th to Mr. Rosenfeld and said, "Thank you for your June 24 email and yesterday's fax. Please remind Mr. O'Kelly that he needs to appear before Judge Fox next Tuesday, June 30th at 10:30 a.m. in Manitowoc County, Manitowoc, Wisconsin." That's the history of my contact with Mr. Rosenfeld.
Mr. O'Kelly has just requested that he be represented by counsel in this proceeding. Do you have any objection to that?
My only objection, Judge, is that he had plenty of time to do it. And Mr. Tepler has driven up from Chicago. I've driven up from Milwaukee. This seems to be a pattern of conduct that I have. I do not intend, and I don't think if the court's going to allow that and adjourn this meeting for another date, that any other witness fees should be at Mr. Kelly's expense.
Well, if the court...
I don't know that I can deny him a right to counsel, but I think he's had plenty of time to work that out. And I would add, Judge, I'm sorry, that we have been seeking these documents since February, possibly earlier, of 2008. We've had substantial amount of correspondence. He knows exactly what we're looking for. In March, he actually responded and sent us some stuff. That was in 2009, in March of 2009. He sent us some stuff. It appeared from the numbering that some of the things were missing. We have asked him for an address so we could serve him with process. That information was not forthcoming, and we basically had to chase him around the country, to track him down, and do this. And it's like taking us over a year and a half to get to this point.
Well, look, if I'm going to grant him the right to have counsel, I would simply move this for later today.
Your Honor.
Yes.
Is it possible for your office to call Attorney Travis Glant and speak with either him or Debbie?
That's fine. Our judicial assistant can do it. See if you can arrange a time that Mr. Glant's available.
Thank you, Your Honor.
I don't want this to continue ad infinitum. Let's let's resolve what needs to be resolved. And
I agree, Judge. I mean, this is the thing that's holding up Mr. Dassey's appeal.
just recess for 5 minutes and see what Mary can do with
Thank you, Your Honor.
Mr. Glant. My judicial assistant talked to Mr. Glant. He's available at 2:30 this afternoon. His office, Mr. O'Kelly, is a half block down the street. I'm expecting that you're going to go there right now.
I'll go there right now.
And we will reconvene this matter at 2:30 this afternoon.
Thank you, Your Honor, for your consideration.
Judge, to resolve any issues, I have 2 wit releases that I would like to file at this time signed by Brendan Dassey concerning the release of privileged information.
Does Mr. O'Kelly have a copy of either or both of these?
He does not, Judge. I don't believe he does.
All right. Mr. O'Kelly, the first of the releases signed by Brendan Dassey says, quote, I, Brendan Dassey, hereby release my former investigator, Michael O'Kelly, from the constraints of the attorney-client privilege only when communicating with my present attorneys, Stephen Drizzen and Robert Dvorak and their assistants, unquote. It says here, and probably it says, quote, Mr. Sigelski may disclose attorney-client confidence to Mr. Dvorak, Mr. Drizzen, and their assistants, and may release any notes and tests or test results and any records to us, end quote. The second release is one specifically addressed to Wisconsin Statute 905.065 and 942.062. It says, quote, I hereby request and authorize Mr. O'Kelly to disclose only to my current attorneys the existent circumstances and results of any and all polygraphs and or other truth testing devices or procedures collectively truth testing devices and parent that may have been administered to me by Mr. O'Kelly at any time. I further request and authorize Mr. O'Kelly to disclose any oral or written communications related to the truth testing devices only to my current attorneys and to produce any documents, files, photographs, correspondence, polygraph results, test results, notes, emails, electronic files, audio or visual recordings, physical objects, or similar materials relating to the truth testing devices only to my current attorneys, including without limitation the materials requested in the subpoena ducis tecum served upon Mr. O'Kelly on June 19, 2009. I do not authorize Mr. Kelly to engage in any disclosure or communication related to the truth testing devices other than the specified disclosures and communications enumerated herein, end quote. It proposes to be signed by Brendan Dassey, and there is a notary public signature as well. Do you have any question about either of the releases?
The document before, Your Honor, this is the first time hearing about that.
Well, that may well be, but do you have any question about the scope of those releases?
I have no questions about that, Your Honor. I do have a question. Could I have a copy of that to take to the attorney? My next question is, am I allowed to talk to Mr. Glant about these issues? Because the release says I cannot. However, how can I communicate with an attorney when I'm barred from it?
Mr. Dvorak?
Judge, I think under the circumstances, as long as the court would not be construing this as somehow of a general waiver, it would be appropriate for Mr. Kelly to disclose or to talk about it with his counsel. I don't know that he needs to go into any discussions about results or anything else. And as long as Mr. O'Kelly's attorney is bound by that release?
It seems to me that it would all fall within the realm of the attorney-client relationship, and thus would only be disclosed under those portions of Chapter 905 that would permit that. How about copies of the releases? Any objection to having photocopies made?
No, Mr. O'Kelly should have a copy, and he should present that to his attorney.
Anything else we should cover before Mr. O'Kelly goes over to talk to Mr. Glant?
Oh, I just like a restriction that he's not going to go over the results of the polygraph testing. He can discuss what he did. I don't know that he needs to discuss results, but...
Mr. O'Kelly, are you okay with that restriction?
Well, I'm not real comfortable with that because that's limiting my attorney as far as making decisions. And I believe in the complete product, and he's going to have a non-disclosure at any rate with respect with how much information is given to him.
Yeah, Judge, I withdraw my comment. I agree. If as long as it's understood that the attorney is bound by the terms of this release, I think Mr. O'Kelly is entitled to get whatever advice he needs to come back into court and present whatever he has to present.
You understand that, Mr. O'Kelly?
I do. Mr. Glant's an officer of the court, so I would, he's...
All right.
He's respectable.
Anything further? I'll just have Mary make photocopies, give them to Mr. O'Kelly, and he can go over to see Mr. Glant.
Thank you very much, Your Honor. Again, one last question. Directions to his office because I have not been there.
Dumbass. Yeah, we'll give you those in just a second.
Thank you.
We don't need to do that on the record.
Thank you.
All right, until 2:30, we're adjourned.
Thank you, Judge.
We'll see you back.
Guess that's an edit for Zoe.
Sorry.
Somebody get that page and line number. Okay, I'm kidding. All right.
Are you recording this? I didn't even know you were recording. Sorry.
I am not. I'm not recording.
Oh, okay. All right. Okay. Line 13. This is, we're back on the record with State of Wisconsin versus Brendan Dassey, 06CF88. Appearances, please.
Good afternoon, Your Honor. Attorney Robert Dvorak and Attorney Just Tepper, appearing on behalf of Mr. Dassey.
Your Honor, Attorney Travis Glant, I'm making a special appearance. I'm appearing with Michael O'Kelly, who has issued a subpoena to appear here in court today on a specific issue.
We began this morning, and the court spread upon the record some background that led up to the hearing today. We, I think, convened at approximately 10:30. We were in session for about half an hour. Mr. O'Kelly requested that he be permitted to have an attorney appear here with him. Mr. Glant is here this afternoon in that capacity. Mr. Dvorak, this is your motion. How do you want to proceed?
Well, Judge, I think there are two issues. Number one, is Mr. Dassey entitled to this stuff, which seems to me to be a legal issue. And second issue is, what is there? What's left? We have to deal with Mr. Rosenfeld's letter, which I think is a factual issue, which I'd like to take testimony from Mr. O'Kelly.
All right, Mr. O'Kelly, come on up to the witness stand, please.
Your Honor, just to make sense, it seems to me we ought to deal with what it is that we should turn. Is he obligated to turn over? Is there any issue about the facts that Mr. O'Kelly is obligated to turn over his work product in this case? I guess I'd like to know that first.
Mr. O'Kelly, why don't you remain seated for a moment?
Yes, Your Honor.
Mr. Glant, I realize you're sort of thrown in the fray here well into the game. Do you contend that Mr. Kelly or Mr. O'Kelly, has a right not to turn over the work product that was generated on the behalf of the defense of Brendan Dassey?
If I could just state a couple of things, Your Honor. Thank you first for acknowledging my late appearance in this matter. I did want to ask the court if the court had a chance to review the documents provided by Mr. O'Kelly this morning. There's some statutes and some other information.
Review them right now. It's a rather small bundle of documents.
I guess, Your Honour, while the court's taking a look at that, I just wanted to say that Mr. O'Kelly was provided with a release and authorisation signed by Mr. Dassey today. There was the very first time he has seen such a release, and he has requested such a release in the past. I have reviewed that release, and I believe it meets the concerns. It appears to be Mr. Dassey requesting that this material be given to his new attorneys. And I just want to state this was discussed between Mr. O'Kelly and Mr. Dvorak, as I understand last week. I point out that this release was notarized on June 23rd, 2009, which is a week ago. There was a discussion about this on June 18th, and Mr. Dvorak asked Mr. O'Kelly if he still wanted the authorisation, the release and authorisation, and Mr. O'Kelly said yes, he does. Mr. O'Kelly doesn't want to be here today arguing about these issues, but he was never provided with this until today. I want to state he's not being uncooperative. He's been requesting months that an authorisation be provided. If he would have been provided with that, we wouldn't be sitting here today. The concern is this. There's a specific there's a specific statute that makes it a crime to release this polygraph information that's being requested without a written authorisation. 942.063 is where it indicates it's a Class B misdemeanour, and that was part of the information provided to the court. We do have such written authorisation at this time, which references actually the statutory section as well as the polygraph privilege section of the evidentiary statute. We are aware that counsel for Mr. Dassey has used a release in the past based upon Mr. O'Kelly's contacts with another colleague on a separate case that had been handled by Mr. Dvorak. Mr. O'Kelly's here. He had to cancel a class he was teaching. He may have to cancel another one that's supposed to teach next week. In terms of why we're here today, I guess Mr. O'Kelly would ask to reserve the right to request additional reimbursement and other possible sanctions for us having to be here and receiving an authorisation on the day of this hearing signed by Mr. Dassey.
Mr. Dvorak, response?
Thank you, Judge. It's just factually not accurate. We've been requesting this stuff from Mr. O'Kelly for a year and a half, going back to February of 2008. He has never once requested, and I don't have any email, letter, or anything else where he is requesting a release. We have left numerous messages for him, which he has not returned, phone calls for. He, in any event, Judge, in March of this year, when I spoke with him, sent us some materials. So if there was any issues concerning a release, he's certainly waived any claim he may have had about that. We have gone through all of this material. We have made significant requests. He flat out told us that he's not going to give us this stuff, and he's just taken an incredibly inexplicable defensive posture about this. He said in the past that you are trying to get Mr. Dassey a new trial, and I'm not going to stick my head on the block for that. He's made some comments like that a couple of times, and it's factually not accurate. So, but it seems to me, Judge, then that the bottom line here, however, is that there is no argument that Mr. Kelly is obligated to turn over whatever it is that he has in terms of his work product on behalf of Mr. Dassey.
Wow.
Right. All right. Let's set aside for a moment the verbal jousting about what it is that was said to whom and what. What is it specifically, Mr. Dvorak, that you're looking for?
We are, it's in my subpoena ducis tecum, Judge, which should be a copy in the file. We're essentially looking for everything Mr. Kelly has. There are references and material that we have, for example, where Mr. Kelly claims that he has tape recorded all interviews with Mr. Dassey. We know from correspondence with the Sheriff's Department that he brought equipment into the jail and he wanted permission to bring equipment into the jail to do whatever, perform polygraph test. It's whatever else may have been involved. So we're certainly looking for all that information, all that material. My understanding is there are also photographs, which he has acknowledged, and back in March when we had a conversation, wanted to know if I wanted the photographs in color or black and white. So we're looking for everything that he has. Everything that he's done on this case, including electronic communication with Mr. Kaczynski, results of any polygraph testing that he has, depending on which machine he used, whether it's an electronically done or if he's got charts. And if he's got charts, we'd like it reproduced in a continuous fashion so that we're able to review it. Whatever notes he has of interviews with witnesses, we're relying on what's in the subpoena. If the court doesn't have a copy of that, I can provide one.
Oh, I'm sure I do. All right. So what I hear you telling me is you're looking for tape recordings of all interviews with Dassey, any polygraph results, any photos that Mr. O'Kelly may have taken in the course of his employment, any emails between himself and Mr. Kaczynski, notes of any witness interviews. Mr. Glant, do you have the subpoena in front of you?
I do, Your Honor.
Are you contending that there's anything in that subpoena ducis tecum to which Mr. Dvorak is not entitled?
I didn't compare the subpoena to the release. I'm assuming the release covers all of that. I believe that he would be entitled to whatever Mr. Dassey releases to them. And if that's all covered in the release and authorization signed by Mr. Dassey, and if Mr. Dassey is making that request, then Mr. O'Kelly does not have a problem releasing that. There is a concern that I believe Mr. O'Kelly has expressed about inculpatory evidence that is in or could be in some of this material.
Well, Mr. Glant, that's why we're doing this in the context of an ex parte hearing, so nobody is here from the other side that can use that information should there be a successful appeal can use that information on a retrial of the case. So you're looking at that subpoena ducis tecum. I'm looking at the release and authorization that was signed and notarized on June 23rd, 2009. It appears to be about as broad in its reach as it can be, with specific references as well to the statutes implicated in the truth testing devices. So do you agree that that's what the release said? The release essentially says the defense team here is entitled to anything it wishes to have that Mr. O'Kelly generated as part of his work on the Dassey case.
I do, and in fact, that subpoena is referenced within this release.
Right.
So if Mr. Dassey is making that request, I believe he is the one that we have to look to give such a waiver and release, and it looks as though counsel has provided that.
Well, I'm not sure we should have had to go that far, but since we are that far, it's all there right now. With that then said, is Mr. O'Kelly going to be resisting any of these requests?
No.
No.
No. Can I just state for the record, Your Honour, there was reference by Mr. Dvorak about sending materials previously. Those were, as I understand, they're called surveys, which are part of the test results. And with Mr. O'Kelly's materials, the authorization signed by the person taking the test that does allow the release of those surveys, so that he had an authorization for that. The rest of all of this, he had nothing for until this morning.
Well, if I credit Mr. Dvorak, he never requested to have anything.
I understand Mr. Dvorak's point on that. I don't know why the burden would be on Mr. O'Kelly to request a release and not on counsel to send a release saying, my client wants this information, here's a release signed by him allowing you to give me everything.
Well, look, I don't want to spend the rest of the afternoon discussing it, but I'll advert just for a moment to what I said a few minutes ago. I'm not sure a release was necessary once they became appointed counsel to Mr. Dassey, but we're beyond that point. So let's not make this sideshow that's going to run the whole operation here. When can this material be provided?
Right now. I've got it in my pocket.
You have what in your pocket?
Well, the materials. It's a jump drive, Your Honor.
Oh, fuck. Oh, Mr. Dvorak.
Well, I'm puzzled, I guess. I thought it was all destroyed, but I'll take whatever he's got, and I'll look at it and see if we feel that it complies. That's the best we can do. I don't know what he's got on this thing.
Mr. Kelly, be seated, please.
Yes, Your Honor.
What is that? What is it that you tell us that you have on the jump drive in your pocket?
If I can put it in on a computer, I can read it off the screen. If there's about, I think, 8 to 10 files, 11 files. I'm not sure how many there are. And that everything that I have on the Dassey case is there.
Well, my understanding was that there are some tape recordings that counsel is requesting.
Those are gone. The attorney has lost that box. He still hasn't. I talked to him an hour ago, and he still hasn't found the box. And I don't understand this. Ken is not that kind of an attorney who would lose anything. And I sent it, return receipt requested. So I know he got the box. He acknowledged getting the box.
So that's what I'd like to take some
Your Honor.
testimony about.
Let's take some testimony. Come on, come up here, Mr. O'Kelly.
Yes, Your Honor.
Do I read this part? Michael O'Kelly, called as a witness herein, having been first duly sworn, was examined and testified as followed. Be seated, state your name and spell your last name for the record.
Michael John Bastard O'Kelly. O apostrophe Kelly.
Bastard. Examination. Mr. O'Kelly, when did you deliver your stuff to Attorney Rosenfield?
It was between March 9 and March 11 is my recollection, according to my emails back and forth with Ken.
Okay. Where did you deliver the stuff from? Where did you get it from? Where was it physically?
I accumulated it in my different storage places, and I put it all in one box. I was gathering that earlier this year, and when your email became threatening, my concern was that the materials could be jeopardized.
What was threatening about my email?
Not your email, rather your conversation and the conversations I've had with the Northwestern folks. It was almost a circus. And I became concerned that when I was traveling, that the materials could be jeopardized. And I talked to Ken about it, and Ken said, "You send me all the materials right now, and I'll deal with Mr. Dvorak."
Okay. Now, well, all right. That's a different issue, I guess. So I asked the question though, where was the stuff delivered from? Where specifically was it?
I don't understand your question.
Where did you have the stuff stored?
I had it in Chicago. It was in Des Plaines and also part with me.
Okay. And do you have that receipt for the return receipt and the receipt from whoever the delivery service was? Do you have it? Do you have that?
It was sent by a U.S. postal, as I recall, and I can get the receipt.
Okay. Would you produce that for us, please?
Of course, yes.
Thank you. And was there a cover letter that was sent with it that described what was inside the box?
No, I boxed everything up.
Okay. Did you ever itemize what was in that box?
No. Ken gave me basically that date to get the package to him, and I asked him if I can. I'm going to copy it, and he says, "You're not listening, Mike." He says, "I want that package."
Can you slow down, please?
I'm sorry. Ken said, "You don't understand. You're not listening, Mike. I want that."
I guess, Your Honour, if I could enter an objection, anything that might be attorney-client privilege. I'm not sure exactly what the relationship was, but conversation between him and his attorney are certainly privileged.
Mr. Dvorak?
I don't understand that, Judge.
I'm going to overrule the objection.
Thank you.
Go on.
Ken asked me. Ken gave me that day to get everything in the mail to him that day.
Okay.
And so I copied as much as I could. I didn't copy. I scanned it.
Okay. So what you had physically, describe what you had that you put in that box.
They were recordings. They were. Where'd you go, Jack?
I'm here. I didn't hear Rhonda. Line 3. Line 3.
Here.
Take them one at a time.
Here, hang on. Let him finish first.
I'm sorry. All right, go ahead.
They were recordings that existed only between Mr. Dassey and I. No other recordings were ever made. There were, I believe, photographs. There were surveys, which were he has all the originals. There were my notes, I believe, and that would have been on yellow tablet paper. I can't, the polygraph information was also there. I'm not sure what else. If I could look at the jump drive, that's what I sent basically.
Are you saying that everything you sent is on the jump drive?
Not the recordings, of course. The recordings can't be recorded on the jump drive, but all the documentation is there.
Let's talk about the recordings for a minute. What were the recordings recorded on?
Well, they were recorded on a videotape. I don't believe there were any audio tapes because I don't recall using an audio tape for this. All
right. So you videotaped all of your conversations with Mr. Dassey?
Probably most of it, I believe.
Okay.
I had the equipment there. I don't know if it was on all the time.
All right.
Because I know you're being specific.
Is this a digital video recorder?
No, it's tape.
Okay. What kind of tape is it? VHS 8?
Oh, no.
millimeter?
No, I believe it's a high 8.
Okay, which is a digital product, right? Are you familiar with that?
I thought it was analog.
Okay. Have you? How many high 8 tapes did you have?
There were at least 4, I believe. I can't remember the specific number though.
Are there multiple interviews on each tape?
I believe so, because I would use one tape continuously. Is that what you're asking me?
Yes.
Yes.
Okay, so there's probably several hours worth of conversation.
Yes and no. There were times Mr. Dassey is completing the survey, which is a large part of the time, and where there is no communication between he and I whatsoever. I'm simply present in the room while he's completing the survey.
Okay. And you did not make any dub of these tapes?
No.
Or download any of the stuff onto your computer or hard drive or otherwise digitize that information?
Absolutely not. No.
Did you ever show that or hand any of that information over to Mr. Kaczynski?
That's where I was trying to figure out. At one time, when you and I were talking pleasantly, and I thought I did. However, I don't believe that Lynn says that I didn't do it. No, I'll take Lynn's word for that.
All right. Let's talk about the photographs. Are the photographs all the photographs that you had on the jump drive?
I believe so. I haven't looked at it, so I don't know. For some reason, I don't think I scanned those. For some reason, I might have. I don't have. I don't think I did.
Oh, what a fucking idiot.
You took the words right out of my mouth, Rhonda. Oh my God, man.
Oh, God.
Okay, we're at line 12. We're halfway through. Let's just pause right there. Pause and reflect for a second before you guys die.
Oh.
God. He's an idiot.
He's scared shitless is what it is.
Aye.
Yeah. Oh, yeah. Well, yeah, because he's worried about he's going to impeach himself.
I mean, I'm sorry, but if Brendan has gave him a release to say he wants all the information given to his new lawyers, that means all the information. That means photographs, interviews, the lot. You know what I mean? No bits and bobs.
What was it he was saying was lost?
Videotapes, the audio recording, which would be the audio recordings, basically.
Oh, well, as BB would say, how convenient.
Well, it really is, because it's really strange that all of a sudden this lawyer is telling him, hey, you get that stuff to me right now. Don't worry about making no copies. Come on. You need to get that in the mail. What?
Yeah.
Why would you not want a backup? Come on.
All right. So is that things can get lost?
I guess. I don't know. So, all right.
Just, it's killing me how he's like, and when you and I were talking pleasantly.
I know. Oh my word, man. He's acting like a 5-year-old. You spoke to me. You shouted at me.
And then when you got shitty with me, I decided to be scandalous and shady.
Yeah, when I wouldn't turn over the stuff that you were asking me for, then you weren't talking nice to me no more. Yep. Come on. Yeah. All right. Let's move on. Line 12. Everybody good to go?
1 second here.
Okay. All right. Yeah, I need to get a drink myself. I don't know what I'm doing. Okay.
I'm ready.
Okay. Line 12. All right. But what you sent to Mr. Rosenfeld were the actual photographs?
Perhaps we should clear on what photographs we're talking about. There's a photograph of the inside of the Avery trailer where the incident allegedly took place. There's a photograph of a stop sign that says dead end. There was a photograph of the outside of where Mr. Dassey lived and also where Mr. Avery lived. They were side-by-side mobile homes.
How many photographs are we talking about?
I thought B4, 5.
Oh my.
Okay. And were those photographs taken with a digital camera?
I have no idea. They weren't mine. They were. I did not take the photographs.
Where did you get them from?
My recollection is I got them from Mr. Chinsky, and they were photographs provided through Discovery.
Okay. Now, the surveys that you're talking about are written documents, are written things that Mr. Dassey fills out, right?
Correct. And I fax those to you. And there's a built-in release on page 2.
You did you now you sent us.
And I have those also on the jump drive.
Okay. When you sent those to us, you designated those 1, 2, 4, and 5. Was there a survey number 3?
I thought you asked, and I answered that question, and I thought I told you that was either a misprint that I had to redo. There was some scanning issue, I thought, because the scanner will automatically go 1, 2, 3, 4. And I thought there was a scanning issue, and so I simply restarted the scanner, and that's why there's a number jump. But everything was provided to you.
Are you saying that you started all over again?
No. I would scan 1, which I have 0, 0, 1, then 0, 0, 2, and then 0, 0, 3. If there's a jump, it's because one of the process got started, and I said, no, delete the process because there was a problem in the scanner, and you put it back through and it gives it a number, a new number.
Okay.
Same item, just
All right.
new sequence.
So we have numbers 1, 2, 4, and 5, which are 4 surveys.
And that's all I got.
And that's all you have.
Correct. And those have a built-in release, as I indicated.
Your notes on yellow pages, did you photocopy those?
I believe so.
And those are on the jump drive?
Yes.
Okay. Polygraph info. What did you mean when you say polygraph info?
Everything to do with that polygraph test. The charge, the questions, the pretest data, everything's on that polygraph chart.
Okay. Now, are you using charts, or are you using a digital machine that
It's computerized.
it's computerized? And does that computer have a camera and audio built into it?
It does.
Machine. Was it the audio and the video on at the time that you?
It was. It was.
One at a time, please. Finish your question, please.
I apologize.
Was it on at the time that you did a polygraph test?
My recollection is it was on.
Okay. Is that audio and video portion on your jump drive?
No, it is not.
How do you get do you still have that machine?
Oh, yes.
And does that machine store that information?
No.
What happens to the audio and video portion of it when you complete a polygraph?
It's on the it's on the instrument. Well, it's on the computer itself.
Okay. It's on the computer. What's on the computer?
Any data created on that polygraph during that session.
Okay. So that would include the charts?
Mm-hmm.
And it would include the audio?
Correct.
And it would include the video?
Correct.
Anything else?
It would include the pretest data, such as the person's full name, date of birth, the gender, address, bio information.
All right. And is that one done in a written format, a verbal format, or both?
Sometimes I will actually take notes from the person and then manually enter it while they're doing something else, such as filling out a survey. In Mr. Dassey's case, I thought I entered it as he and I were speaking. That's my recollection.
All right. Now, how do you transfer that information into something else to so that you can store it, so that you can have a record of what happened?
I usually don't transfer it. I usually stay on the computer. I have since changed that practice because of the crashes I've had.
I'm sorry. When you do a polygraph, you're saying that you would never save the polygraph information?
No, it would stay on the computer.
Okay.
Unfortunately, I've had experience that I lost quite a few of my polygraphs because I had one computer crash and I've got no data at all.
All right. Now let me just understand. We're talking about the computer that you're talking about. Is that a separate item from the polygraph machine, or is it part of that polygraph machine?
It's two different items.
Okay. So you have a separate standalone computer that you plug into your polygraph machine that records all of the data, that digitizes all the data that you put into the polygraph.
That is correct.
Okay. And the forms, the written type things that are put on your computer, in what format?
They would be on the Lafayette system.
Okay.
I guess.
I guess what I'm asking, is it a PDF document? Does it come out as a Word document? Do you know?
It comes off as the document, as the software for Lafayette software.
Okay. It's
not a PDF or Word.
All right. And the audio and video portion, how's that? In what format is that recorded on the hard drive?
You're asking me questions about the polygraph that I don't know.
All right.
You'd have to ask an engineer.
Engineer?
We're over on trains. We're over on a train now or something.
Okay.
Lordy. Okay, line 2. After a polygraph test, have you ever gone back on your computer and looked at the polygraph, the audio, the video, and the entire record of it?
Oh no.
You've never done that?
Never had a reason to.
You've never had a lawyer asked to do that?
Nope.
Okay. Do you have a backup system for your computer?
I do now. I didn't. I didn't then.
You didn't then?
Nope.
When did you get a backup system for your computer?
About 2 weeks ago, 3 weeks ago.
God. I'm sure you did. What happened to the hard drive on the computer that you used when you were interviewing or working on Mr. Dassey's case?
That has crashed.
Okay. What happened to the computer?
The computer's been trashed because it's an old computer.
Meaning you've thrown it away?
Yes, it has no value.
Okay. Did you make any effort at all to salvage any of the materials on that computer?
Yes, I did. And that's how I was able to get most of Mr. Dassey's files.
When did you do that?
It would have to have been this year. And I believe it happened sometime between January, I'm guessing. Could have been December and March.
Okay. And did you were you aware that at that time that the video and audio stuff was still on the computer, right?
The answer is no, because I don't go in the computer to look for the items.
Okay.
I don't.
You knew that we were looking for this stuff. We had requested that stuff.
Correct. Yes.
Okay. Did you do anything to when you downloaded it? I take it your computer was working?
Oh, sure.
Okay. And did you do anything? Did you consult with anybody about how to download this stuff?
No,
Okay. And you're telling us that you never tried to do this before.
no.
When you
Well, hang on. Does no mean you're telling us you never tried to do it before, or that you did try to do it before?
What's the question? How's that?
God, I repeat the question, guy. Have you ever tried to download stuff from your polygraph related computer
Oh, no.
before?
No.
Have you ever deleted in polygraph information from your computer?
No.
Have you ever hooked up that computer up to a monitor so that you can open up and see what's in the selected file?
I don't understand your question.
Oh
All right.
my God.
Jesus.
Let me ask you.
Jesus Christ. Sorry, Jack.
That's okay.
Let's bring in the engineer.
Yeah, really. All right, line 6 or line 5. All right, let me ask you this. You downloaded some of the stuff from this computer onto, what did you download it onto? A disk, another hard drive?
It would have been a CD-ROM, I believe. I was trying to save everything too.
Okay,
That's my recollection
all right.
because I used Sonic for that.
Okay, and is the CD-ROM built into the polygraph computer?
Oh, no.
Okay, so it's a peripheral.
Correct.
So you plug the peripheral into your computer, and I guess it's a laptop.
Yes, it is.
Okay, so it's got a screen. You turn the computer on, right?
Correct.
Okay, and how do you know where to go? Is there an icon on the computer?
Sure. It says Lafayette. It's a big red L.
Okay, and you double click on that, it opens up,
Correct.
and within that folder there are names of polygraphs that you've given. Are there files? What is the
Yeah, there would be, yes.
Okay, so there would be a file that says Brendan Dassey or something like that, referencing his case.
Sure. Or John Jones or whoever the subject is.
Okay, and were there more than one of those, or was all this work product in one file?
Oh, no, it's only in one place.
Okay, so that when you did the polygraph, you would set it up so that it would be saved to a file, to that specific file on your computer.
I think Lafayette has their software set that way.
He's hung up on that Lafayette. Okay, and when you... I'm sorry, go ahead.
I don't manually do anything. I think it's automatic because of how the engineers have the software set up.
The engineers again.
Boy. So when you open up the Dassey file, what do you see?
Well, you actually see nothing at all because you would start with creating a file and you would name it a DAS. In this case, it would be Dassey file.
Let me rephrase the question.
Sure.
Okay, you're done with Mr. Dassey's case.
Sure.
And in January, February, whenever it is, you're trying to replicate the file. You open up Mr. Dassey's file. What do you see?
I don't recall opening it up, and that's part of the issue. I don't recall opening it up.
Okay, now when you create a CD, do you just take? Can you just take the file, the folder, rather that says Dassey, and drag it to the CD-ROM?
No. With mine, I can't. I don't know how to do that.
How did you select what to copy and what not to copy?
I would highlight the name of the file, and it would be in the Sonic software. And you simply say copy file, and it would go ahead and make a data disk.
Okay.
It's all automatic.
All right. And are you saying that you Yes, you're
The
fine.
engineer set it up.
Are you saying that did you highlight everything in the Dassey file?
I don't know that you highlight things as far as I can recall. I think it's just one item, and that's what you use to transfer.
Okay. I thought I heard you say that you highlight something and then you click transfer, or how do you select what to do?
You highlight the person's last name or how the file is, whether it's Dassey or Jones, whatever it is.
Okay. So you highlight Mr. Dassey. You say burn this file?
Correct.
All right. And that should burn everything on your computer with respect to Mr. Dassey's file?
Correct. And that's what I sent to Ken.
Okay. And you sent that to Ken on the format of a CD-ROM?
Yes.
And you only burned one of them. Is that what you're saying?
Yes.
And then sometime after January or February, you're saying your computer crashed.
I got multiple crashes. In fact, I have another that I have to buy.
When did your computer crash after you downloaded this stuff?
I can't give you the date because I don't recall when it crashed. I can probably get you all those dates because we had multiple times.
Okay. You didn't have any, you didn't have any problems with it from the time that you gave Mr. Dassey these polygraph tests till sometime in January, February of 2009?
Right. But it was an old computer, though.
Okay. But you didn't have any problems during that period of time, right?
What period of time are we talking about? I'm not.
Between the time that you gave Mr. Dassey any polygraph tests or recorded any of his statements using this device until you downloaded it onto a CD-ROM.
I had problems. I didn't have any crashes.
Okay. And now, when you have a crash, did you take it someplace to have it fixed?
No. You can call Toshiba and they walk you through it.
I see. And what part of what they walk you through is how to restore the stuff you lost, right?
Yes.
Okay, and did you do that?
Yes.
Okay. And so some of the stuff that you thought you lost, you got restored?
Most was not.
Okay. How do you know that?
Because when we finished working on it with the senior technicians, a lot of things were gone.
Okay. Was the audio video recordings gone?
I did not check for any of those.
Okay. Did you ever back up that hard drive?
No.
Ever?
No.
Even before, when you were doing this with the senior technicians, were you advised to back up your hard drive?
No.
Sure. And
No.
this was this with Toshiba?
Correct.
Now, why did you feel necessary to send this stuff to a lawyer?
Objection as to relevance.
Over, he can answer.
I was uncomfortable with your behavior. You had lied to me.
I lied to you?
Oh, yes.
How would I?
Motherfucker, sir. I don't recall the specific lie at this time. You lied to me. And when someone lies to me, I reduce it to printed form, which is why I stopped taking your calls. You went on the motherfucking, and you said,
Excuse me?
I'm sorry.
What did you say?
Mr. Dvorak went on the NACDL, National Association for Criminal Defense Lawyers, and made a posting that I was holding myself out as a super investigator, when in fact I was simply a guest speaker at a super conference. And I've never held myself out as a super investigator. Never, ever, ever.
Okay, well,
I began to have a strong distrust in you, and that's when I called Ken Rosenfeld, who I do trust. He's a defense attorney. He understands your thinking. And I asked Ken what to do, and I laid it all out for him, what was going on in the circus from Northwestern that I was dealing with. And Ken said, I'm now your attorney. This is work product. Get me your file today.
I see. And you also made that association. Do you recall the first conversation with me on the phone?
I know we ended pleasantly, I thought, but it started off a little rough.
Right. And because you had accused Mr. Drizzen, Professor Drizzen, at Northwestern and his associates there of lying to you, right?
I did, and I caught them in line.
And
They
specifically, you mentioned.
Here, whoa, talking over each other. Where's this going, counsel? I'm not.
I'll withdraw it.
All right.
I'll go somewhere else. That's fair, and we're off track here. All right. So you felt compelled, for whatever reason, to send this to Mr. Rosenfeld. What was the urgency? Do you know?
I traveled quite a bit, and Ken said, "Get me the file today." And I when you were hire an attorney, you don't second guess the attorney. You follow the advice and you go with what he says.
Okay, and you did that sometime in March, right? Early March?
My email to Ken was on the 9th, and I know that he and I talked in those 2 days, which is why I said between the 9th and the 11th.
Okay.
It may go out to the 19th, but my recollection is it was either March 9, 10, or 11 when it went out in U.S. Postal.
All right. Why didn't you tell any of us that you had a lawyer and that you had sent this stuff to the lawyer?
I believe I told Mr. Vaughn that I retained an attorney. Mr. Vaughn said that he and you were going to call Mr. Kaczynski. And once again, Mr. Kaczynski and I had been in contact both email and telephone. And as late as yesterday, day before yesterday, and Mr. Kaczynski once again said he has had no requests from Mr. Dvorak or from Mr. Vaughn. 0 requests, and he's made it very clear. The statute says no release without Mr. Dassey's signature. Do not do it.
And that's not my question. My question is, why didn't you tell us that you had retained a lawyer and that we should contact that lawyer?
I hired Mr. Rosenfeld. Mr. Rosenfeld said that he was going to take care of it. To be frank with you, as I was telling Mr. Glant today when we were talking over here to the courthouse, when we were walking over here, Ken dropped the ball. He didn't call you. That's what I told Mr. Glant. I says this probably wouldn't be here today if he had called Mr. Dvorak and once again demanded the release and the letter. I simply followed the law. You mentioned about our first conver.
Here, you're not asked a question.
Communicate by email. You're familiar with email? You use email, correct?
Correct.
Okay. And where do you keep your email stored?
In my computer.
Okay. Do you save your email correspondence to your computer?
No.
Okay, but you saved some of it, obviously, because you gave some of it to the court.
Actually, it's not saved on my computer because once again the crashes. I've stopped saving things because I found out that we can just simply leave it on the server, and so what's on the server stays on the server. You don't have to worry about if your computer crashes. It's still there on the server.
Okay. And so all of your email correspondence has been saved to your server, right?
Yes.
And does that go back to your time when you worked with Mr. Dassey?
I didn't check, but I could. I could certainly find out.
All right. Who's your provider?
It's MSN.
Okay. And would you do that for us, please?
Sure.
Now.
And so we're clear, what exactly are you asking to get you? Because that's not on the jump drive.
It's any correspondence that you had with anybody about this case?
Okay.
Whether it's the law enforcement, DA's office, your lawyer, a witness, the press, any correspondence you had with anybody concerning Mr. Dassey's case.
And just so you know, Mr. Dassey's case was discussed only with Mr. Kaczynski, and that would be it. There should be no emails going to law enforcement, certainly not the press, certainly not to witnesses. Any discussions are limited to Mr. Kaczynski and I.
I know that's wrong because I know he sent emails to law enforcement. Moving on. Line 15. When did you, after March 12, did you have any other correspondence with Mr. Rosenfeld?
I don't think Ken and I talked anymore about this once I sent the package off. There was no reason to. I don't recall any, and if I did, I would certainly provide you that.
Okay. When did Mr. Rosenfeld tell you that he had lost these items?
The day I was served, I think.
Convenient. How convenient.
How convenient.
Yeah.
First BB.
Would you remember what day of the week that was?
It's the same day I had you on the speakerphone.
Okay. That would, the day of the hearing, I think.
I think that was June 18th.
Right.
Same day I had you on the speakerphone because I would have called. I believe I called Ken later that day because I had to finish my class.
Have you yourself looked at what's on this jump drive that you're about to turn over?
And no.
You never did? So you've never opened it up?
They're in zip files.
Okay. Do you know, is there any software that we would need to access those materials that you know about?
No, it should be. I know they're PDF files. And as long as you have Adobe Acrobat Reader, you can open them up with 5 and better. I don't think there's any Word files. You're going to need the Lafayette software to open it up. And I can't give you a copy of Lafayette software. That's proprietary. You have to get that from them. But I believe those files have been converted to PDF. So you can actually see the Lafayette files in PDF, I believe.
Okay. So, and what's that?
No, I just called him an idiot.
Oh.
It's fine. Go ahead. Carry on.
Line 6. Okay. So, and when did you download this stuff from your computer to your jump drive?
I believe this was all March 9.
So
that's my recollection.
So in addition to making a CD-ROM that you sent to to Attorney Rosenfeld, you also downloaded stuff onto the jump drive.
Oh, no. I saved that to my computer, and then I put this on the jump drive for you.
And you saved what on your computer?
What I was sending to Mr. Rosenfeld. I was trying to scan things. That's what I have on the jump drive. That's what I was able to save because thank God I saved it.
I'm sorry. I'm confused. You created the jump drive around March 9?
No. The jump drive's been created on or about, I guess, June 18. I transferred the data from my computer to the jump drive.
From the computer?
Okay, this is interesting. Okay, so the computer was working as of June 18.
You're not understanding. When I told you that I had the call with Ken, when I had the call with Ken, I said, Ken, I'm going to go ahead and start scanning. He says, you're not listening to me, Mike. He said, I want that file out today. And at that time, I started scanning, and that's what I have.
On March 9, you started scanning?
I believe it was March 9.
All right. Somewhere between March 9 and March 11, you started scanning.
Correct. And by the close of business day, before the post office closed, I stopped scanning, boxed everything up, And that's what Ken has. And I have the results.
Okay. Now, when you say you stopped scanning, was there still other things that were left for you to scan?
Yes. And for some reason, I don't think I scanned the photographs because the photographs were from the prosecution in discovery. And they were things like the inside of the Avery trailer. It was that sign that says dead end. It was things like that. And it wasn't anything that I made for a photograph. And I'm presuming, since it came from discovery, that either Ken or Lynn Kaczynski has it, or the prosecution would still have it. That's because it wasn't my stuff. It wasn't my photographs.
All right. And this was scanned onto the same computer, however, as the stuff that you had burned onto the CD-ROM.
Correct.
It's the same computer.
Correct.
Okay. And then you used that computer to create the jump drive.
Correct.
And you created the jump drive on June 18.
Yes.
Okay. And you copied everything from that computer onto your jump drive.
Exactly.
Okay.
Objection. I need to clarify everything. When you say everything, clarifying everything related to the Dassey.
Yeah, of course. Of course. I'm referring to Dassey, yes. So I guess you don't know for sure whether or not there's a video or audio recordings on this jump drive.
No, I don't.
Okay. Judge, I don't think I have any questions at this time. Any other questions? I do have a request, and that is for Mr. O'Kelly designate somebody in his state. Perhaps is it his counsel as an agent for service to process, so we don't have to go through the problems, the history that we've had in trying to reach him and to access him, and we have a mediary. There's obviously some misunderstanding between Mr. O'Kelly and the lawyers for Mr. Dassey, which I don't think we need to resolve. I don't know that they're relevant to any of this. We can certainly have that debate if needed, but I don't think we do. But I think it's. I'm frankly pleased that he's retained counsel and we have somebody to talk to. And so I would ask that court designate that Mr. O'Kelly designates somebody as an agent for service of process as consultant for conduit for conversations with him.
Mr. O'Kelly, do you have any problem with that?
Yes, I do. And I can explain myself to Your Honor.
Go ahead.
When Mr. Dvorak and I were pleasantly speaking at one point in time, I explained to him I do travel and I would like to do the same thing with him that I do with any other attorney. If you have anything at all to serve, the simplest way to do is to email in an attachment with an acknowledgement of service. I will then sign the acknowledgement of service, photocopy it, or rather scan it, email that back to you, and then mail hard copy to you. And I told them that early on that's the best way to do it. It's the most simplest approach, and that way it avoids any dispute, and it would certainly avoid this.
Mr. O'Kelly, do you recall your conversation with me about that when and you made the comment that I will not deduct your service of process assuming it is valid. Did you qualify that it had to make sure that it was a valid service of process? Do you remember qualifying that?
Well, I don't know if I qualified it or not, but whether I qualified it or not, I told you if you simply send me the document with an acknowledgement of service, I will sign it and get it right back to you.
Okay, and
you have twisted a lot of things I've said.
Do you recall an email that I sent to you where I informed you that Judge Box gave us a return date? We're happy to work with you on whatever it's convenient for you in terms of your return date. Do you remember that email?
I'm not sure if I do, but I do want to point out that you have lied to me and you have refused to talk to Mr. Rosenfeld. So when you say that you want to communicate with our attorney, you failed to communicate with Mr. Rosenfeld and you refused to.
I have not had an opportunity. I've been busy, but
I think you refused it, sir. His conversations. He sent me the email.
Here, I'm not interested in listening to the two of you argue. Mr. O'Kelly, from my perspective,
Yes, Your Honor.
you certainly haven't done anything to facilitate counsel's contact with you. This has been going on for a substantial period of time. Now, you tell me you have an objection to designating Mr. Glant as your agent of service here in the state of Wisconsin. I'm going to order that he be your agent of service here in the state of Wisconsin and that you maintain contact with him.
Yes, Your Honor, I will.
All right. Now, you're going to turn this jump drive over today?
I'll do anything, Your Honor. Your Honor requests.
All right. Well, I'm not going to request. I'm going to order that you turn it over to counsel today before we leave the courtroom.
I'm sorry. I didn't hear that, Judge.
Jump drive.
Yes, you're going to order that.
I'm going to order that he turns that over to you today before we leave this courtroom.
Your Honor.
Yes.
If Mr. Dvorak or his partner has a computer, all they have to do is open it up and transfer the data. If they don't have one with them, we can certainly go to the public defender's office. Sorry, my page jumped.
That's okay.
What page is it?
73.
3, yep.
Oh my gosh, what a shit show this is.
No
O'Kelly
shit.
lies worse than Robert Durst on the stand, doesn't he? Oh my God.
Jesus, he's
Wow.
such a piece of shit. If they don't have one with them, we can certainly go to the public defender's office across the street and they can transfer data right then.
Going to order that you turn the jump drive over to them, Mr. O'Kelly. Do you understand?
Yes. Can I make a copy of it first? Find out what I'm turning over?
Well, you haven't looked at it.
That's why I can say can I make a copy? And I can go to Mr. Glant's office and make a copy.
Do you have processing facilities to make a copy of the jump drive?
I'm assuming it's just a straight jump drive, and
yes,
I can put it on our
exactly
computer there.
Look, Mr. O'Kelly, stop talking over the other people, all right? You do?
Yes.
Okay. We'll have the lot of you then go over to Mr. Glant's office. Mr. Glant can make a copy of the jump drive. The jump drive then will leave with the attorneys Dvorak and Tepfer. What else do we doing here today?
That's it for today, Judge. We will make an effort to see what's on it, and I can't think of anything else that we need to accomplish today.
Well, if I read the record of the testimony, Mr. O'Kelly said that he will produce any correspondence about this case with anybody that exists on his server. Additionally, he said that he would produce the receipt that evidenced his mailing of the box of documents to Mr. Rosenfeld. I'm correct in stating that?
Yes, Your Honor.
How long is it going to take you to do these things, Mr. O'Kelly?
I will get my Visa card out and I'll look at the chart, contact the Postal Service with that date.
Can you do this within the next 14 days?
Yes, Your Honor, I can.
Court will so order. Anything else?
Your Honor, I have a class. Could you make it 21 days?
Any objection to 21 days?
We have we have a deadline with the Court of Appeals that we've extended 3 times. The Court of Appeals is getting short with us.
I think you're within, I think it was 60 days the last time.
Right. And that built in for us, Judge, time to take in what it is we have absorbed, what we have, and put it into the massive materials that we already have. But
let's do it within 14 days, Mr. O'Kelly.
Yes, Your Honor.
And Mr. Glant, you understand that you're going to be his agent for service of process here in Wisconsin.
I do understand, Your Honor.
So you're going to have to keep in close touch with Mr. Glant. You understand that?
Susan, on 8.
Yes, Your Honor.
And let him know where you're going to be, if you're conducting classes in other than your home base.
Yes, Your Honor.
Anything else from you, Mr. Dvorak?
No, Judge.
Mr. Glant.
Your Honor, I know we're running out of time here. I just wanted to confirm with the court that the court has heard enough in terms of the issues being about sending the box, what was in the box, and those items. I did have some follow-up questions on that. Perhaps it's for not at all the moment.
You didn't say another day. I understand you may have some questions, and unfortunately, I have a number of other things that have to be done before the end of this afternoon. How many questions do you have?
I don't have too many questions. I just know how long the responses are going to be.
Give you 5 minutes.
Mr. O'Kelly, about sending the documents and other files, whatever you had, to your attorney in California, at the time you were doing that, were you feeling pressure to turn these items over?
Exactly.
And had you ever been sent any type of authorization signed by Mr. Dassey, by any attorney from Mr. Dassey?
Nope.
So the only authorization you had was the one that was built into one of the forms you had him sign?
That's correct.
And those were the survey documents you emailed to Mr. Dvorak?
Correct.
What were your concerns about turning over this information without release signs?
That I'd be in violation of Wisconsin law. Specifically, I believe it was 942.06, I'm guessing.
And were you aware of whether or not counsel for Mr. Dassey had utilised authorization that would allow the release of this in other circumstances?
Yes. He's currently attorney for Michael Fink, and one of the experts he did employ has used that a release to obtain the information, which is a smooth process. And that's what Mr. Kaczynski had advised me not to do until I had a release, and that Mr. Kaczynski explained complied with Wisconsin law.
Judge, I don't know what the relevance of this is.
Either. But I told Mr. Glad he could have 5 minutes worth of questions, even irrelevant ones.
Okay.
Okay.
And for the record right here, this is where it skips. Page 79 is gone. We're skipping straight to 80, or 79 to 80 is gone. It's going to go from 78 to 81, I think.
Weird.
That's weird.
What could they be redacting?
I don't know.
Very curious.
I cannot imagine. Anybody? Any thoughts? Anybody?
Yes. Anybody in chat got any ideas?
Yeah, it's really curious that they would force this redaction.
Yeah. 79 and 80. I mean, what could be in that? I mean, there's nothing in the questions that are even relevant to what's just been said. So why 79 and 80?
I don't know. It was only supposed to be, like I said, about half of page 79, line 16 of page 79 through line 2 of page 80. I have no idea.
Mm.
And you guys saw it there in the record, but they wouldn't let me have it. I mean, I'd gladly pay the $1.25 for each page, and they could just redact what they didn't want, what he didn't want in the record. So I have no idea.
Weird.
Yeah, I see Travis has joined us, but maybe he has some idea. Well, I mean, I don't know if he could read anything more into it than what we can see, but I can't see anything other than this arguing back and forth. O'Kelly's calling Dvorak a liar, tell a bunch of lies, and there's those people from Northwestern. They're apparently the evil spawn. He's avoiding them as well. It sounds like so.
He's a weirdo, man.
Well,
Okay.
Anyway, let's finish up here. Line 3. Thank you.
All right. You may sit down.
Thank you, Your Honor.
Mr. Dvorak, why don't you draft an order reflecting the court's orders? I'll remind the parties this is an ex parte. The order will be ex parte. The file will be kept under seal. Anything else, Mr. Dvorak?
Not at this time, Judge. Thank you.
Mr. Glant?
No, Your Honor.
All right.
Thank you.
Thank you, Your Honor.
You're welcome. Get out of my fucking courtroom.
Yeah, it was clear he was getting quite agitated with Mr. O'Kelly. You could tell by his tone.
You lied to me. Travis says, ask the question again. What was redacted? Explain that to him, Jack.
Okay. Let me pull it back up here, and I'll show him so he can understand it. Let me get back over here before I pull that up. Okay. I'll go through it again here right quick. Web pages.
It's just, I mean, even his answers and his attitude. It's like, you shouted at me. I would do nothing. Jesus Christ, man.
Yeah, you were mean. You were mean to me.
Yeah, exactly. It's like playground antics. You know what I mean? I'm not looking at you because you were mean to me.
Okay.
Well, we all know he's not a computer engineer.
Oh my God. he was. I'm just wondering if he's the one that Calumet County has employed right now. Considering all the trouble they're having, needing a Windows 98 computer to copy some audio files. Really? It's scary. It's absolutely scary, frightening. Anyway, Travis, let me explain this to you. So this is a compilation of Brennan's record. And as I was going through, they had a couple of motion hearings starting, I think maybe, okay. Right here on 523. There was one meeting here that was filed under seal, ex parte. But on 624, they had another one. It was also filed under seal. Those two right there, just so I'm clear, those two right there, I believe are still sealed. I'm not positive, but nonetheless, there's no transcript. So those are out of the question to get. They're too expensive, even if they were unsealed. The one that we just read was this one here. It was sealed, just like he said. Okay, fast forward to January 12th of 2010. This is just right before the meetings. And Judge Fox, this is where it says right here. The court orders that the transcripts of 6/30/2009 ex parte motion hearing be unsealed, but the portions on page 79, line 16, to page 80, line 2, be redacted and remain sealed. So I made that request in this process of talking to the clerk of getting the 4 records that I did get. And I didn't get a reply as to why I couldn't get those pages. I was just told that pages 79 and pages 80 would not be included. They're redacted. But clearly it's only portions of those 2 pages. So that's all I know. I mean, that's all I could seem to get out of them.
So I can't imagine what in the heck could be on those pages that needed to be sealed.
This right here.
Not for what we've just read. Not for just for page 77 and 78. With what we just read, there was nothing relevant to what that gallant was asking questions about. Period.
Unless
I bet
Mr.
it was
Dor-
Kelly calling Dvorak an asshole.
Well, that's what I'm thinking, that they got into a big old racket. That would be my guess. They got in a big racket,
Could have been. Yeah.
And-
Maybe.
But possibly.
because they've been snipping at each other for pretty much the entire time. I found this one funny too, that he ungagged Mr. O'Kelly, because if you remember, part of that order is that really he wasn't allowed to talk to anyone except the lawyer about this. So he ungagged O'Kelly. Anyway, that's basically all I could get out of it, Travis. So I don't know. Maybe I'll try again to see if I can get those 2 pages with the redactions in place. I'm fine with that. I don't have a problem with
Even if it is just petty nitpicking between the two parties, let's see it. Let's read it. If that's all it really is.
I agree.
We're adults. We can handle it.
Yeah, we're big.
There was quite a bit of that in here already.
Yeah.
Which wasn't redacted. So
Mostly on O'Kelly's part, honestly. I mean, Dvorak was like, "Excuse me," kind of attitude.
Can I put in my 2 cents worth?
Please do.
Of course you can, Doc.
He probably told the judge, "Look, Judge, I've got a folder of hardcore pornography on my computer. Please ignore it. Please ignore it, because I'm going to give a copy to Fassbender. He does have a deep secret."
That's it, Doc. That's got to be it.
That's funny. Yeah, I don't know. I thought that the entire thing was kind of strange, but I think it's very possible that they got into a big racket. The judge let him go on for a few minutes, but he thought to himself, "I'm not going to let that out in the public. This looks pretty bad."
I kind of think so too, maybe, Travis. I really do think that's probably what it sounded like anyway, possibly was going on.
Yeah, that's what Travis said too.
Slanderous comments, yeah. Well,
and like I said, I'm okay with that. I don't mind reading that. I'm not going to be offended by it.
Well,
In fact, I might be entertained by it.
What's that, Doc?
My other point is, just listening to that, it's truly amazing. What a complete, total waste of time, 1, because nothing was achieved at all. And 2, you could tell that O'Kelly, he got sprung. He got sprung like a chicken, and he wasn't very comfortable being put on the stand. And he was going to drag this out as much as possible. And my 3rd point is, pity Brendan Dassey that ran into Michael O'Kelly.
And Kaczynski.
And Kaczynski. But Michael O'Kelly, he was unbelievably devious. Yeah. Unbelievably devious.
And remained that way, Doc.
Oh, correct. And, people like this, they really need to be taken to task, because the amount of damage that they cause is phenomenal. And, and we all know, instead of acting on Brendan Dassey's behalf, he was working for the state and they had them in their pocket.
Yeah.
It's a shocking thing.
But it's not even that, Doc. It's just too convenient that he gets served, and then all of a sudden he's posting this boxy documents off to a so-called lawyer, and then the box gets lost.
The box gets lost.
Oh, yeah.
Lost.
Yeah. But,
well,
you saw what happened with that incriminating email he had about the Avery and Dassey families, right?
Oh, yes.
So you could imagine what else he had that would have been really inflammatory, and he wanted to make sure it got lost.
Yeah.
Lost in the mail, because there probably would have been a civil suit on him as well. So,
and then the computer crashed.
You would say.
The computer
crashed. And then it
how convenient. And he just threw it away.
But let's wait. He had just made that thumb drive copy. I'm sorry, jump drive. My bad. Jump drive copy on June the 9th was basically 21 days prior to this hearing. So the computer was still working then. right?
Yeah.
That's what he said.
Correct.
Yeah. Yeah.
But
he lied.
Right. He flummoxed that earlier because he said basically he was talking like in, back in March or April, the computer basically just crashed. He had to throw it away. So this guy.
You want to know what's scary is that at least at that point in time, he was a professor and he was teaching classes in investigation. That's terrifying.
It is terrifying.
Yeah, but that was all a crock of shit. There's no way that a teacher like that is going to use a computer that crashes all the time. There's no way a teacher like that doesn't know how to open files or save files or transfer files from one fucking place to the other. You know what I mean? For a teacher, come on. You know what I mean? He's acting stupid in that courtroom, but he's no fucking stupid. You know what I mean? But that's the way he played it, and that's the way poor Brendan's been played all the way fucking through this, because they've done nothing but destroy that lad's life, and including losing documents that could maybe vindicate him and prove that it was all a lot of crap.
Oh my God, Travis says he became a cell phone expert for prosecution all over the country, including Texas, and made up more stuff.
He did. He did it. He did a case here. He did a case here in Michigan. I can't tell you exactly what year, but it was after this. He charged them. I think that case I think Travis is talking about. He can correct me if I'm wrong, but I think he turned in some outrageous bill, and the judge chopped it down to way down. Did give him hardly. I can't remember. It was. I mean, he charged him like. I don't want to say. It seemed like it was close to $100,000 or something. It was some outrageous amount. He did a case here in Michigan where he turned in like a phenomenal bill and all this work. He had cell phone work he had done, cell tower mic, blah blah blah, and the judge chopped it down to like he turned in like I want to say it was like a $30,000 or $40,000 bill, and I think the judge ended up giving him like $8,000 or something.
For fuck's sake!
Yeah.
But isn't O'Kelly the classic example of a charlatan? The classic example of how he can get away with the things that he did is completely inexplicable. You could tell that the judge, he had enough. The judge gave him 14 days to do a process that'll take 2 hours?
Right.
Yeah.
Right? And then he goes, can I have 21?
Can I have 21 days?
Yeah.
I'm thinking to myself, why don't you go on a holiday to the Bahamas while you're at it? It's come on.
Yeah.
Fox he sounded close to finding him in contempt. Go ahead.
I think that O'Kelly really did think that Brendan was guilty.
Yeah.
Probably.
He knew how underhanded he was, all this shit that he did.
Absolutely.
He knew it was wrong.
Absolutely.
And all of his boohoo tears and blue fucking ribbons and all that happy horse shit. Kiss my ass, O'Kelly.
Travis is saying he thinks O'Kelly had no understanding of fact that he breached his fiduciary duty to Brendan over and over again. That he didn't understand that. Boy, I don't know.
But hold on. Kaczynski and O'Kelly had a plan in place.
They did.
And the plan in place was, 1, Stephen Avery was guilty. 2, Stephen Avery made Brendan Dassey do all these horrible things to Teresa Halbach. 3, we're going to go for a plea deal as long as Brendan Dassey testifies against his uncle, writes a 1-page summary, hands it over to Ken Kratz. See you later. Thank you, linesman. Thank you, ball boys. Everything is cool.
Yep.
So they had a plan. They had a strategy. It horribly backfired, right? So instead of representing Brendan Dassey and assuming that your client is actually innocent, they went in there knowing full well that Brendan Dassey was guilty. And what they were trying to do is minimize the fallout, right? So they never went in there to say, is my client innocent or guilty? They went in there with the idea, my client is guilty. Let's see the minimum that we can get away with in terms of a sentence. And that explains all the bizarre behavior of Kaczynski and O'Kelly.
That's right. That's exactly right. They had a plan, and everything was, and also surrounded by going through Brendan to get evidence against Stevens so they could turn it over to the state. And it didn't matter if it inculpated Brendan. It drags him down too. Oh, well, that's okay.
Hence that letter that he got Brandon to sign, and when he said, "Hey, Brandon, come on, do it, otherwise I can't help you."
Yeah.
Remember?
Yep.
Yep.
Yeah.
I was going to say, Jack, the giveaway was the fact, if you have a look at the questionnaire was written in a manner that Brendan Dassey was guilty.
That's right.
You have a look at the wording of the questionnaire. There was no option, Mr. O'Kelly, I never did any of this. O'Kelly said to Brendan, what's missing from your answer? And he goes, Teresa Hallbart, because then I can't help you. Right? Yep. So poor Brendan had to, because he was threatened. Do you want to spend your rest of your life in prison? No. So he had to rewrite the story, right, to include Teresa Hallbach and what they allegedly did to her. Then, of course, that's what happened the next day. The interview, then the phone call to the mother was all set up like a bunch of dominoes. Bang, 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 bang.
Just nothing short of a travesty. Nothing short.
And as a defense investigator, Travis, how can you say that he didn't even realize what he was doing? I don't understand that.
Yeah, he knew exactly what he was doing.
Okay.
Especially when he's got all the...
Telling him he failed the polygraph.
Yeah, telling him he failed. But not only that, Susan, having the pictures and the ribbon and everything like that.
He didn't mention that, did he? He didn't mention that photograph.
No, exactly. He knew exactly what he was doing. I don't believe for a minute that he didn't know what he was doing. I mean, he might act stupid, but he's no stupid.
Oh, no.
Well, it just doesn't make sense.
No.
If he's there to defend this client, he's doing the exact opposite. So,
yeah, I wonder how much he got paid to secure the confession.
Yeah.
He turned in a bill. We've got it. His statement of services. I think he seemed me like, I want to say it was like $8,000, something like that. I don't know. I'd have to pull it up. I know I did a big write-up, years ago now on Reddit, and examined everything that O'Kelly did and Kaczynski did. It was really pretty ridiculous. Travis had actually put up there a little bit higher up in the comments about the, what do you call it here? Travis says, Google this $100,000 cell phone expert in the Cummings capital murder case, a trial. Judge recused. Yeah, I remember reading that article. It's been a long time, but I do remember that. It's absolutely ridiculous. And plus this other case that happened here in Michigan.
So he's saying O'Kelly wanted the judge recused? The cell phone expert?
No, I don't remember exactly what happened. I would have to read the article. I don't want to say, because I'll say it wrong. I don't recall. I just remember it was
That's crazy.
I just seemed like I remember that O'Kelly wasn't paid nowhere near that, and it was a case that he wasn't called to testify. He was just, he provided information. So, but this guy, him and Kaczynski, between what those, and what a lot of people don't know, I guess people here probably do, many that have been here for a long time, Kaczynski had a defense investigator. And then he was brought in, O'Kelly was brought in to do this polygraph, and all of a sudden he's the investigator. So something a little slippery happened there, in my opinion.
A little bit.
But, sorry.
Oh, go ahead.
I was going to say, but what O'Kelly did, it was very, very sneaky. He saw the crack and he went in, right? He saw the opportunity to become more involved. So Kaczynski really just hired him for just a small component. However, he expanded out his role, expanded out his services, and he inflated the price. You know, his service fees just went up and through the roof. That was his aim. He only had a small involvement initially, but then it greatly expanded.
Yeah, the $300 polygraph, Doc, because everybody else in the area wanted like $500, I think, is the excuse they came up with to begin with. The state would only pay.
Well,
go ahead, Alice.
Sorry, Kent 3334 in the chat says 37,000.
9,000 more than the public defenders received from the case. Took 37,719. 9,000 more than the public defender received from the case.
Yeah.
Wow. Yeah. Well, anyway, I thought this, I didn't know going in, what would we get, you just never know. And there was no reports anywhere about any of these hearings in, 2009. Still unknown about these other ones. We don't have foul play paid for the documents that I got, from the money we have set aside, but you don't know what you're going to get because there's really no reporting. But I just thought it would be good to have for his record. We're going to be getting in soon to. I know Doc will probably want to be in on this. The readings of the post-conviction hearings in 2010. Yeah,
for sure. But I'm so glad that you guys read this out, because it's sort of like a forewarning of what is to come.
Oh yeah.
Right? If you were honestly going to sum that up, that whole 80 pages, what did you get from that? If you were to sum it up in one sentence, what did you get out of that reading?
God, I don't know if I could do it in one word. Somebody else go. Charlatan?
Yeah. Best I can do is 2 suits and a pissing match.
Yeah.
It's terrible. It's absolutely awful. You could tell that the stage was pretty well set before they ever started, because of the, Dvorak saying, we're trying to get you, and you keep dodging us, basically. So, and I believe that. Look what he did with.
Oh, I believe that wholeheartedly.
Yeah.
As soon as he got any information that he was going to be called, he avoided it. So I don't think whether Dvorak or that sent him any emails or no, with him saying, "Oh, I've told you just to send me an email and I'll sign it till you get it." I bet you he did send him emails and he realised what it was and went, "I'm no answering that. You can fuck off."
Right.
He deleted those from the server, though.
Yeah, probably.
Probably. Yeah.
But his computer crashed.
Jack Hembury is wanting to. He says, "Just saw the tweet with the link to this video. Sorry to repeat. What did you discuss?" Want to give Hembury a rundown?
Yeah. First, we the first thing we did, because we just got it kind of thrown in our lap right before we went live, we read the state's response to Kathleen Zellner's thing to the Wisconsin Supreme Court, and then we moved into this hearing, or this document that we just read. Is an ex parte meeting that happened June 30th, 2009 in Brendan's case between Dvorak and Michael O'Kelly. They were trying to get all information from O'Kelly. This is what I gathered from it. They've been trying to get him for the last 18 months to get material that he had. And it was just one dodge after another. And I guess they finally ran him down and got him served. And of course, he was going to have to appear. And then the surrounding, he says he had a box of materials that he contacted his attorney out west, and his attorney demanded that he send that material to him immediately. Well, all of a sudden, wham, bam, this attorney loses it, or the material, this box of material gets lost, which means any audio, video recording between O'Kelly and Brendan gone. The other materials that are gone as well. However, somehow he had computer crashes and all this apparently cropped up in the meantime, but he was able to make a thumb drive like 20 days earlier to this meeting. It had certain things on it. We don't know exactly what all's on that thumb drive because they didn't really say, but apparently there is some materials that they were able to salvage. So that's basically what is basically a pissing match between O'Kelly and Dvorak. Judge Fox, to his credit, wasn't going to really tolerate too much of his crap. So
we actually read the entire
80 page. Yeah. 80 page motion, or it just says 80 page ex parte motion. That's all it is.
Yeah.
So he's asking a question.
Yes.
So all and most of the records created, held from his pretrial meetings with BD have disappeared. Well, a good portion of them. He had some, but yeah. He
had some in his pocket. He brought some of them with him in his pocket.
on that damn
jump drive.
On that thumb drive, he brought with him. But yeah, because that polygraph machine that he had also had a video recorder with it, audio video recorder that ran during the polygraph, and that's where they wanted that. Dvorak wanted that recording, and he also wanted all recordings between Brendan and himself. Those were lost too. Those were all on high videotape or whatever. So all gone, according to O'Kelly.
Yeah, Travis says that the defence team had emails from O'Kelly to others besides Kaczynski. They knew it, and they were going to see if he was going to lie about it. Dvorak was setting him up, confirmed that his emails were on the server.
Yeah.
So, I think Dvorak was trying to trip him up. Definitely. And then that's when he started giving it, but you were mean to me.
Yeah. You lied to me.
You lied to me many times. You lied and twisted this whole conversation.
You and Drizzen
are liar.
You and Drizzen are so mean.
Liar, pants on fire.
I'm withholding things from you, but God, you guys are so terrible. Yeah, it's really bad. I mean, I'll make the document available. I didn't.
When he figured out. Oh, sorry, I just was reading Travis's comment. Sorry.
Yeah, go ahead, read it.
Travis says, I also think that he made the jump drive when he thought he was going to be paid to testify at the hearing, when he figured out he wasn't going to be paid, and they didn't think he was a hero, but pig.
Yeah. That's a great comment, Travis.
Valid point, Travis. Valid point.
Hey, knowing him, he probably turned in a statement of service in order to get paid.
Yeah.
Yep.
Well, that's why. Yeah, what's that, Doc?
Are we able to put that on a T-shirt?
No doubt.
Didn't he mention that in the beginning?
He did, well, yeah, because Dvorak was pretty much beside himself because he's asking for a lawyer all of a sudden, knowing this hearing's coming, and he's saying like, well, if we're going to have to reschedule this, it's going to have to be on his dime, and I'm asking the court not to pay for any more of his expenses. So, yeah. He apparently, I don't know where he came in from, but I'm guessing it was out west somewhere, so they probably paid for his trip to fly out and hotel. So.
Glant? No, Glant was in Wisconsin.
I'm sorry?
Is that who you're talking about? Who are you talking about, Jack?
O'Kelly.
Oh, gotcha. Sorry, yeah.
I think he was somewhere out in Oregon, or I don't remember where he was at. Maybe he may have.
In California.
I think he actually. I think they caught up with him in Salt Lake. So, actually, Rhonda,
God.
you should have known. You should have known where he
Oh.
was at, actually. I'm going to talk to you.
Oh,
There's
I'm
going
gonna
to
have
be
to look into that. Was O'Kelly in Salt Lake City?
I can't remember.
Deny just recuse everything he did. It's not true. Really, I never knew that. That's interesting.
But this Doc is right. This is a great segue to what happens in January with the hearings. They're terrible. They're absolutely terrible. They go a little bit better than this, and there's certainly a lot of revelations. But my God,
Everybody's asking, so there's no record of what questions Kelly asked Brendan during the polygraph.
no. Well, if there is, we don't have it. I'm not saying it doesn't exist, but we don't, unless it's revealed somewhere else. I don't think we know what the contents of the thumb drive were. Not all of it, anyway. If it's referenced somewhere, nothing's coming to mind right now. Maybe that's a question that Laura would be willing to answer. Maybe Drizzen. I don't know. I'm not sure how approachable they are. So, but this is a good.
In the
I'm sorry.
So in the docket report that you kindly showed me, it mentions that these were ex parte hearings, which has special significance.
Which means that the state was not present, right?
The state was not present,
right?
Because the judge.
Is that what ex parte means?
Well, it means one side or the other is not present. Yeah. And they did that. Fox did explain that because he didn't want anything that might have been said in one of those meetings to have been landed up in the state's pocket where they could use it without full consideration. I think that was his wording or something of that nature. So to his credit, he did do that. And I think it was the right move because certainly we had no idea what was going to come out of it, which turns out that really wasn't too much except for, more of the same things that we expect from O'Kelly, really.
Yeah.
So any more questions before we wrap this up? We're at 3 hours, and I know it's been a long roll, and I appreciate everyone hanging in there. For Kathleen's or the state's answer to Kathleen, and then going through this because I didn't plan on the other at all. Like I said, that landed right.
Yeah, that just
like 5 minutes.
We were getting ready to go live.
Yeah, we're getting ready to go live. Like 5 minutes before getting ready to go live, and somebody said, "Hey, state, we got a state's response from the state." So, who was the lawyer who Fox allowed to question for 5 minutes? That was Glant, Glandt. That was a guy that O'Kelly actually called the day before when he landed the day before in Manitowoc. Some guy out of the phone book that he called and tried to get to represent him, I guess. And the guy said that he couldn't talk to him. He talked to his receptionist. They broke the meeting, after they got to the hearing that morning. O'Kelly asked the judge for a lawyer. He wanted a lawyer present, and so that's where this other part came in. Anyway, they called. The judge's clerk called down there to this Glant's office and arranged for O'Kelly to be able to get in there. And the guy agreed to come down at 2:30 for this meeting. That's who this guy was. He's out of the blue. We don't know anything about him. That's who he is, Travis. Oh, that's okay. Yeah, I understand. I'll make the report. This hearing. I'll get it linked in the document description for anyone that wants to read it. I didn't do that earlier. But I'll get that link for anybody that wants to download it and read it, whatever. So
yeah, his office was right across the street.
Yeah, it was right there, real close to the courthouse. Hey, Jazz Naz, late for you, man. Thanks for dropping by. Any more questions before we wrap up? Anybody?
Can I just make the quick comment?
Please.
Has anyone ever encountered two cases like this, Stephen Avery, Brendan Dassey, in which there is a massive amount of obfuscation at the highest levels? Has anyone ever encountered this?
Never. Never.
No, I
Doc, I've read a lot of cases. I've never seen a case where a defense attorney and his drug investigator into it as well agreed to work for the state, colluded with them basically, and did it for months. And it really hurt Brendan from a time standpoint. It really wrecked him.
Yeah.
I think Henry said Watergate. Yeah, that was pretty bad. No doubt. No doubt, Henry. That was pretty terrible.
Since Watergate.
Well, I mean, that's
But
federal
Watergate,
level.
at least they caught the plumbers in Watergate.
That's true. I never have, Doc. It's so bad.
Yeah.
Okay, everyone. Really appreciate everyone coming and spending some time with us. And it was a little bit of a drawn out process, but when we get to these other hearings, we won't do those live because they're really long, but they'll be recorded. Obviously, we'll get them memorialized for everyone to listen to, and I think there probably would be more participation, when we premiere them because they're so terrible. But this plays right into O'Kelly's character and Kaczynski too. So.
Well,
Anyway.
and when we record them, they can be edited, and all of our
goofiness, mistakes,
all of our silliness can be edited out.
Yeah, we have to thank Zoe for that because she's so good at it. She likes doing that kind of stuff. She looks at it as a puzzle and she loves them. So she takes out. We write down where we screw up so bad, and when we redo it, she's able to go back and edit all that stuff out with her software. So.
And Barry says Salem witch trials. Yeah, that too.
Yeah, no doubt. Anyway.
And it's great to have Rhonda back.
It is.
Oh,
welcome back.
Thank you.
Yeah.
Thank you so much, my West Coast homie.
That's right.
If I got
representing.
Yeah, representing.
It was good. She had to step away.
Kind of anxious to get back into it, but scared at the same time.
Well, Susan has suggested that, and to get you back reacclimatized. So I think it was a good thing. So
yeah, I appreciate that.
No problem.
It was good.
No problem. All right, everyone. Appreciate everyone coming and hanging with us for 3+ hours, and we'll catch you soon. This has been a Foul Play production.
See you, everyone.